Go that way. Go that way. We'll figure it out. Figure it out. Don't worry. Okay.
Please be seated. Please be seated. Good afternoon.
Good afternoon, and welcome to the Appellate Division First Department.
Sorry, we were a little confused on our
confused
sitting,
on our
but one
sitting,
of
but one of our
our judges, as you can see,
is appearing
is appearing
virtually
today,
today.
Judge Gonzalez.
Judge
So
Gonzalez.
you can
So
hear us,
you can
Judge
hear us,
Gonzalez?
Judge Gonzalez?
Yes? Okay,
Yes?
great.
Okay, great.
So good afternoon.
good afternoon.
We right
We
now have
right
over
now have
6
over
hours
6
of
hours of
arguments
arguments
scheduled for today. So we want to
remind
remind you that we have had your briefs and your records, and we are familiar with the facts of your cases. So we just ask you to please ask for the time that you really need. If we continue to have questions after the red light goes on, we will continue to ask you questions. We ask when the red light goes on that you kind of end your presentation, finish the sentence, of course, of the thought, and we will ask questions, additional questions if we need to. So I'm going to call the calendar now. Please stand up when I call your case, and the appellants will tell me how much time you want, and the respondents also. Okay, the first case on the calendar is People versus Davale. Defendant appellant? Okay, and respondent? Okay, we're going to do 6 and 2 and 6. Thank you very much. Goldberg versus Goldberg? Okay, also 6, 2, and 6. Thank you. Stewart versus Amber? Respond? Okay, 5, 1, and 5. Thank you. OFEC Rachel LTD versus Suki. I believe we have 2 appellants in this case. And the other appellant? Okay, and the respondent? Okay, so we'll do 5 and 2. The other appellant can have 3, and the respondent will have 5. Thank you. People versus Jones. Okay, 7, 2, and 7. Thank you. Agramante versus Local 461. Respondent? Okay, we'll do 6 and 1 and 6. Thank you. Herrero versus 2146 Nostrand. There were 2 appellants in this case? 5? 5 and 2. And what about Nostrand, appellant Nostrand? Not here? Okay, what about the respondent? Okay, so 5 and 2 and 5. Thank you. I'm going to pronounce this wrong, I think. I apologize. D. Gilmay versus New York City Transit Authority. 8 plus 2. Respondent? 8 plus 2. You know, I said respondent. Is there a respondent here? So it looks like you're the only one arguing. Do you want to submit, or do you want to make a short argument? I'd like to argue the waiver vote. Okay, so I'll give you 4 minutes if you need anything, I think that should be okay. Thank you. People versus Langhorne and the related case with the same name, that case is submitted. Sta Parking versus Federal Insurance. I know. No, this is for both. And for respondent, cross appellant? Okay, I'll give you 6 and 2 and 6 and 2. Thank you. People versus Addison. Okay, 5, 2, and 4. Thank you. People versus Picone is submitted. Baker and Molnar versus Green Tech Capital. We're going to hear those together. Okay. Perfect. Okay, so 6, 2, and 6. Thank you. Lopez versus 157-161. The appellant? Anybody have any questions? Okay, so we'll take the submission. Thank you, counsel. People versus Reed is submitted. People versus Ruben Gonzalez. Submitted. Hoppenstein versus Hoppenstein is submitted. Tunell versus Maynard is submitted. And Guzman versus Americare is submitted. The only cases we're going to take out of order is Agramont. We're going to take D. Guilme before Herrero. We're going to switch those cases. It's just to accommodate the court. So D. Guilme will be before Herrero, in case you step out and don't want to step back in late. So the first case for oral argument is People versus Cristel Davale. Please step up to the podiums. And you may, as you know, I think, remove your masks during the oral argument. Okay. Okay, counsel, you may proceed.
Good afternoon, and may it please the court. Brianna Walsh of Pillsbury, Winthrop, Shaw, and Pittman, along with the Center for Appellate Litigation on behalf of appellant Cristel Davale. The trial court abused its discretion and deprived Ms. Davale of her constitutional right to present a defense based on battered woman syndrome, given the undisputed history of abuse in this case. In determining whether or not to admit the late notice, the trial court was required to balance Ms. Davale's constitutional right to present a defense with any prejudice to the people. With respect to the prejudice issue, it's important to correct a misrepresentation made in the people's brief. The application was made 6 months before this case went to trial, not on the eve of trial.
Well, the issue is not only in terms of trial, and we'll get to that in a second, but also, when was the defendant arraigned? When was the defendant arraigned?
The arraignment was 17 months prior.
Okay, so, and under the statute, when are you supposed to serve notice of your intent to offer a psychiatric defense?
The notice is required within 30 days of arraignment.
30 days of arraignments. And so now we're 17 months from arraignment?
Correct, Your Honor. But
and then where are we in terms of trial? Are we not 8 days prior to the scheduled trial date?
The application was made on September 14th. Jury selection began in this case on March 20th of 2017.
But when was jury selection supposed to commence?
The case would have been on the calendar, but it did not go forward. It was prior.
I understand that, but the notice was served September 14th?
That's correct.
What was the trial date? Was the trial date not September, I think, 21?
That's correct.
So it was on for trial September 21, and then the notice was served September 14th, but we're still 17 months from arraignment. Is that correct?
That's correct, Your Honor.
And was there a reason stated by defense as to why there was late notice?
Counsel set forth that it was essentially his own ignorance on the topic of battered woman syndrome.
I thought it was also because they were unable to find an expert. Was that not also an issue, that they couldn't find an expert?
Counsel's reason for not presenting it earlier was that he was unaware that it would have been something that his client was affected by.
And did counsel not also state throughout the litigation or throughout the case, did counsel not also make representations to the people that they would not be going forward with a psychiatric defense?
He made those representations, Your Honor, which is why we also argued that it was ineffective assistance of counsel for Mr. Dubin to have not pursued this defense at an earlier date. The record is undisputed that Ms. Davale was subject to routine mental, physical, and emotional abuse by Mr. Cruz over the course of their relationship. The testimony regarding battered woman syndrome was necessary for the jury to understand why Ms. Davale responded to things the way that she did, why she returned to him from a domestic violence shelter after receiving harassing text messages and dropping the charges, why she stayed with him after the people's witnesses testified that he struck her on a daily basis.
Well, what would that have to do with justification wherein she claimed that he had a knife, that he came at her with the knife, and that she attempted to disarm him of the knife?
It was necessary because of the subjective element of the justification defense to explain her understanding of the situation on that day. And the people's witnesses testified that the only person heard struggling that morning was Ms.
But why
Davale.
would it matter whether she was a battered spouse or not if, in fact, she was attempting to defend herself with that impending attack by the deceased?
It was necessary because the people made much of the fact at trial that she returned to him, that she stayed with him after he beat her, that she stayed with him after he wouldn't let her leave the house, and that she stayed with him after he routinely threw her belongings out onto the street. They needed to understand from her viewpoint, as someone who was subject to that abuse, why she did those things. And on the date of the incident, Mr. Pagave testified that she could be heard with her voice muffled and crying, saying, "Please let go of me, Norby, let go of me. Help me, help me." And
wasn't there also some testimony that there was that the relationship was acrimonious in that not only did perhaps he attack her, but that also she attacked him, and that there was a Molyneux determination as well as to instances where she had struck him?
There was testimony by Mr. Cruz's cousin that on one occasion she struck him. There was other testimony in the record that they fought verbally. The people's witnesses testified to Mr. Cruz abusing Ms. Davale regularly. Many times they said they saw her lip busted open, she was bruised, she was bloody from her ear. It was Mr. Cruz who was abusing Ms. Davale physically, not allowing her to leave the home without his permission, not allowing her to work, and she was here at 21 years old with no family or friends in the area. The testimony for battered woman syndrome would have been essential to the justification defense because the jury otherwise had no ability to understand those choices from Ms. Davale's subjective viewpoint as a battered woman.
Counsel,
I'm sorry.
I was going to say, Counsel, didn't the indictment also charge her with first-degree manslaughter?
It did.
So the jury rejected the emotional element or emotional aspect, right? Because that's what first-degree manslaughter is.
The jury rejected Ms. Davale's account, but that was in the absence of testimony regarding battered woman syndrome, which was essential because the jury otherwise could not understand the choices that Ms. Davale made, particularly in light of the
would have had a
people's...
better argument if it was first-degree manslaughter, because then you're going to say, look, the jury had a psychiatric evidence that would have found her not guilty on first-degree manslaughter. This is second-degree murder that she got convicted of. Okay, I got it.
Okay, why don't we hear from the people, and you'll have 2 minutes on rebuttal.
Thank you, Your Honor.
Good afternoon.
May it please the court, Charles Wan for the respondent. As I believe Your Honors have a firm understanding of the facts and the law in this case, unless Your Honors have any questions, respondent will rest on our brief and request an affirmance. Thank you, Your Honors.
Okay, thank you. Okay, you may proceed.
Thank you. The people's failure to refute this history of abuse because they cannot is telling. The trial court should have preserved the record and let Ms. Davale present the defense based on battered woman syndrome. There were 6 intervening months from the time the request was made for the people to have her paired. Given the history of the abuse, the interest of justice favored allowing
I don't
the
disagree with
defense.
what you just said, but I think in my mind, the jury convicted her of second-degree murder. They did not convict her of first-degree manslaughter, which I think if that had happened, I think your arguments about the psychiatric defense would have been at least stronger in my mind, because that would have been something to at least counter the first-degree manslaughter. This is second-degree murder she got convicted of. So they rejected her testimony. She testified at trial, and she told the jury exactly what happened, or her recollection of the events happened on her in terms of the abuse from the victim. That got all
But
rejected.
she also did not testify that the reason that she stabbed him, I think, through the heart was because of any history of prior abuse. She testified again that he was coming at her with the knife and that she was attempting to disarm him of the knife. She didn't, that seemed to go to intent, in her intent to harm him. I don't see where the battered spouse or battered woman's defense comes into play here. It's not a situation where your typical battered spouse, where, the individual has repeatedly abused the person, and, and the person, now he or she comes home and they act in a manner that the individual had always known to be something that meant that was going to lead to some kind of violence, and therefore they, take the initiative or they go on the offense and harm the person.
To address both points, with respect to the conviction of second-degree murder, I think that speaks to why the defense should have been permitted to address the battered woman syndrome testimony, because the jury did discredit her testimony because they didn't have the testimony from an expert explaining battered woman syndrome. With respect to her actions on that day, this was a cycle of escalating violence by Mr. Cruz. It started with harassing messages, and it escalated physically and emotionally. So on the day of the incident, and Ms. Davale's testimony at trial was, in those few moments where she actually did stab him, she couldn't remember. And the jury needed to know why she might not remember that instant, why she thought that him having a knife and coming at her based on those prior events meant that he was going to harm her. But the jury had none of that in front of them, and they couldn't have understood her viewpoint, which is necessary for her justification defense because of the subjective element. The people made it as though she had no reason to have responded that way. There was a history of abuse that every single one of their witnesses testified to.
Okay, any more questions? Okay, thank you very much. Ms. Walsh, I note that you are pro bono counsel on this case, so we would ask you to we would like to thank the firm of Pillsbury Winthrop, Shaw Pittman, for allowing you to come in and argue this on a pro bono basis. Thank you very much for your argument, and thank you to the people as well.
Thank you, Your Honor.
The next case for argument is Goldberg versus Goldberg. Good afternoon.
Good afternoon, Your Honors. May it please the Court, I'm Michael Beda, and I represent the appellant Joshua Goldberg in connection with this matter. On December 13th, 2019, the appellant husband commenced his initial action for divorce.
Well, we do know those facts, and, I mean, the problem here seems to be with the cutoff agreement that we're referring to, as to the date by which valuation would be stopped in the matrimonial case. And so I know that they discontinued, this case was, the original case was discontinued, and then this case was brought, and that's wherein lies the problem, correct?
Absolutely.
So why don't you get
So-
to that? I mean, the wife brought this case and didn't follow the 7-day notice. Instead, she gave a 9-day notice, and they're claiming as a result of that, and the court found that as a result of that, you no longer had the benefit of the September 2019 cutoff date.
So on November 8th, 2020, when the wife commenced her action for divorce, which was prior to the expiration of the date in the cutoff agreement,
Right.
she held on to the notice, and subsequently, within 10 days, she filed a request for judicial intervention, which resulted in Judge Hoffman being assigned to the case. She also filed an order to show cause. That order to show cause was presented to Judge Hoffman on November 17th, 2020, at which point the parties first appeared in, I'm sorry, that order to show cause was presented to Judge Hoffman on November 19th. The parties appeared for the first time before Judge Hoffman on November 19th. They appeared for the second time before Judge Hoffman on November 24th. Both of those instances were prior to the expiration of the cutoff date in the cutoff agreement. In addition to appearing before...
But that's not, I mean, the cutoff agreement not only stated in terms of the date of December, right, but also said that you had to file within the 7 days.
So the clause that Your Honor is referring to is a subordinate clause. It is not the condition precedent to triggering the cutoff agreement.
But it says if either party filed a divorce pleading prior to or on December 13th, 2020, so that's what the wife did, which filing was followed by notice thereof to the other party within 7 days, which didn't happen, then December 13th, 2019 would be used as a cutoff date. So I mean, you know, I was an English major. I used to like all these little, you know, subordinate phrases. But the bottom line is, I kind of think that this was not a very difficult agreement. And if it did some of it, didn't do the rest of it, then didn't you kind of blow it and lose the benefit, which I guess it was a benefit to your client, to maintaining the December 13th, the December 13th, 2019 cutoff date.
So the clause in the essential clause of this agreement is paragraph 3. Paragraph 3 contains the language that if a divorce pleading is...
So Justice Kaepernick just read it. Look, that's what she read from.
Right.
It's paragraph 3, and she read it verbatim. So again, I agree with her. I do not see how you can state that that is a subordinate clause. It says December 13, 2020, and be of no further force and effect, semicolon, however, comma, if either party files a divorce pleading prior to, on or about, etc. So I'm not seeing how is that a subordinate clause?
Because it does not contain the requisite language to make it a condition precedent.
What would the requisite language be? What should have been added?
Subject, the language that should have been in the agreement would have been if, until, null and void. That language is not contained over here. The only...
And so who drafted this, by the way?
That clause was drafted by the Respondents' Counsel.
Without any input by the husband's counsel, right? So it was drafted entirely by Respondents' Counsel, and there was absolutely no input by the opposing side's counsel.
Well, the intention, I didn't say that there was no input. Obviously, there was back and forth in terms of the preparation of the document. However, at the time the parties signed this cutoff agreement, their intention was to withdraw the initial divorce filing, and subsequently, if there's another filing for divorce, that would trigger the cutoff agreement.
But let me ask you something. What happened was, it was served, she did bring another action, and she gave notice 9 days later. Was there anything that you or your client could have done at that point to save the December 2019 cutoff date as you hoped it would be preserved in that cutoff agreement, even though she waited the 9 days? Was there anything you could have done? Could you made an objection that she didn't do it and we think this was unfair? So was there something else you could have done than what you did to have preserved this date rather than sort of let the cutoff agreement expire and then leave us all in this position?
So when looking at the four corners of this document, it did not require the appellant to do anything because the triggering event was the filing of the divorce pleading. There's nothing else in the four corners of this document that required him to do anything. And also of note, this is where the facts come in. You had a November 8th filing, a November 17th notice provided. The parties were in court within 48 hours before Judge Hoffman, addressing an emergency order to show cause, which he addressed in 2 separate court appearances, which all took place prior to the expiration of the cutoff.
So while you're in court addressing those issues, why did you not address this issue?
Because it didn't come up. And when looking at the actual what took place in that court appearance was an application brought by the mother. There is a footnote referenced in the mother's papers about her withholding service of the divorce pleading, and that's referenced in page 44 of the record. There is a reference by Respondent's Counsel that because she withheld notice for 9 days and did not serve within 7, the cutoff agreement was waived. However, of note, Respondent's Counsel takes a different position when we stand before this court, and their position in their papers, Your Honors.
Okay, well, I'll tell you what, let's hear what the respondent's position is, and you'll have a couple minutes to respond.
Thank you, Your Honor.
Thank you. Good afternoon, counsel.
Good afternoon. May it please the court, Jillian Gross, Mossberg Sharma, Stambleck Gross, for respondent Shari Goldberg. We ask the court to affirm.
I have a question. The question I have is, the defendant husband wants December 13, 2019 as the date as the cutoff. Your client says, no, that's not the cutoff date because of what happened according to the agreement. And I'm trying to understand, if your client did nothing, if no one did anything, this cutoff date would have been gone.
That's correct,
right?
Your Honor.
So technically, it didn't matter whether or not she served it within 7, 9, or whatever. She could have not done anything because, unless I missed something in the record, the defendant never said that he had any intention of filing a divorce action, right? Or that he was lulled into some sort of complacency to not file a divorce, because he controlled what happened too. I mean, destiny, you controlled your fate, right? Am I missing something?
You're not missing anything, Your Honor. That's completely right. And what appellant wants to avoid in his argument is the plain meaning of the contract. It is very clear. Neither party performed under the plain meaning of this contract.
You didn't even have to file an action. I mean, you just let it go and then file it like after 2 years later. She could have filed the divorce action, and December 13, 2019 is long gone.
That's correct, Your Honor. And to the same point, nothing prevented appellant from acting under the...
Well, he never said that he was being prevented or precluded or barred, right?
That's correct. And
there was something in the record that indicate, I mean, I think the first case was discontinued, at least what I saw in the record was because there was some attempt to reconcile. But it didn't seem like it took too long before they decided they were not going to reconcile, and everybody was just sitting and waiting. Nobody did anything. He had a few months there, I believe, that he could have brought the case, but your client brought it instead in November.
correct, Your Honor. At any point between executing the cutoff agreement and December 13, 2020, Mr. Goldberg could have acted. He chose not to. He was represented by counsel the entire time. He was represented by counsel when he executed the agreement that was written by counsel collectively. He could have acted between the date that Ms. Goldberg served him and December 13th, 2020, because the agreement is very clear. It says a divorce pleading. He still could have filed an answer during that time. He did nothing, and by its terms, the agreement expired. He cannot get the relief he is seeking because he uses contract principles that don't apply here. The agreement...
If he had filed the answer immediately and not waited until, I think, 2021, something like that, then that would have comported with the cutoff date?
If he gave notice within 7 days, yes, Your Honor, that would have purported with it. He waited until June of 2021.
Right.
Everything was within his control.
Well, that was the question that was posed to your adversary, was what, if anything, could have been done? And he stated that under the terms of the agreement, that there's nothing that could have been done.
Correct. And Judge Hoffman below found that he could have acted, was sort of surprised that he hadn't acted, not sure why he didn't. And why he didn't doesn't matter. He didn't. The agreement expired. If Your Honors have no further questions, we'll rest on our brief.
Okay, thank you very much.
Thank you.
Okay, Mr. Bay?
So, counsel, do you disagree with that? That if, in fact, you had your client had responded and had answered and had, in fact, properly served, then you would be within the cutoff agreement?
Do I agree with that? Under the terms of this agreement, all that was necessitated, all that was needed was a divorce pleading being filed, which could only refer to a divorce pleading being an action for divorce. Because when you plug into the clause the word answer, when you plug the word answer into paragraph 3, that clause makes no sense. So no, I do not agree that an answer would have satisfied the agreement. Also of note, and I go right back.
Well, you know, by saying that, you could also protect yourself, and you can argue this later on. Procedurally, nothing prevented you from commencing a brand-new divorce action, and then later on, you know, you guys duke it out as to who's first in time or whatever, who has priority. But at least in my mind, you would have been able to preserve this agreement, because if you had commenced your action after November 17, when you got your notice, on November 17, 2020, when you got notice, served notice of the complaint, of the respondent's complaint, you could have on November 18th, and this is what counsel was arguing, commenced an action or answer, but you could have commenced an action and served 7 days later just to preserve everything and argue everything else later down the road.
Respectfully, we could not do so because we were already assigned to Judge Hoffman. The RJI was...
I know that, you know that, but a lot of lawyers still do it.
However,
It's to protect yourself.
but that maybe would have addressed one issue, but we had a court appearance already set to appear before a judge assigned to handle the case. Also,
That's why we have all these appellate divisions and books in back of us that says that, you know, issues are issues. I mean, that's what this is all about.
There's the issue of waiver also, Your Honors. The clause that was inserted that we're all talking about over here, this notice clause, that was for the benefit of the other party. The other party over here was Mr. Goldberg. Being the other party, with this clause being inserted for his benefit, it is well settled in this department that a clause inserted into an agreement can be waived by the party for whose benefit that clause was inserted. Over here, Mr. Goldberg waived this notice clause by way of his actions. His requesting the date and the enforcement of the cutoff agreement was the waiver, which is, I'm mentioning to address the question posed to my adversary earlier this afternoon. So there was an appropriate waiver, and waiver can be either express or implied. It can be by way of actions, and his actions constituted a viable and valid waiver.
Okay. Thank you very much, counsel. Both of you have a good afternoon. The next case for argument is Stewart versus Amber. Good afternoon. You may proceed.
Thank you. Lena Armstrong for Appellant, Linda Stewart. We're here today because we're asking the court to review a decision granting a motion to dismiss based on a finding that the pro se plaintiff's action was time barred, that it wasn't brought within the statute of limitations
So this is
period.
a 3211, and as you said, it's a statute of limitations. I'm not understanding. The agreement was in August of 1990, August 21st, 1990. Is that correct?
Correct.
So how do we get beyond the statute of limitations? How do you get to, you set the date as 2014 as the year that the legal right accrued. I don't understand. How do we get to 2014 from 1990?
There's a triggering event that the defendant owes the plaintiff's money when the movie, in this case, was complete and generating revenue. I believe that's in the amended agreement as the trial.
2001 agreement?
Yes. And that's what the Supreme Court relied on in making this determination. There is an allegation in the complaint that the movie was being sold over the internet, Amazon, IMDb, YouTube. I believe
So,
there's.
counsel, this is Judge Gonzalez.
Oh, hi.
So, hello. So, generating revenue has a very broad definition according to this agreement, and it includes being shown in commercial movie theaters. So, to the extent that it was first shown in October of 2009, and the next screening was in 2010, why aren't those the trigger dates?
Because the court would have had to make a finding of fact that those showings were showings in commercial movie theaters, and I don't think you can do that based on this complaint. We cited a case that explains.
Isn't the movie theater called the Roxy Theater in Philadelphia? And the other one is the Independent Film Festival in Philadelphia?
Yes.
I mean, you have to prove, you're saying that there would have had to have been an offer of proof that the Roxy Theater was a commercial theater?
I think there would have to be an offer of proof that that constitutes a showing in a commercial movie theater.
It's the premiere of the movie. The movie premiered at the Roxy.
A lot of premieres, and we cite one case, are four-wall deals where the people who are marketing the movie rent out the theater. It's not a showing in a commercial theater.
But this paragraph in the 2001 agreement, the feature film agreement, says, there's a few ors, commas or semicolons, or any other venue in which the movie is generating revenue. So you're saying that it wasn't generating any revenue? There was proof that there was absolutely no revenue when this movie was shown at the Roxy Theater or the couple places thereafter?
Reading the complaint in the light most favorable to the plaintiff, there is no evidence that the movie was generating revenue when it was shown at the Roxy. That's something that would have to be determined through fact discovery.
But I thought
Counsel,
go ahead, I'm sorry.
Aren't you adding something to this? Generating revenue without making any money is what you're saying, right? But again, the plain language says that generating revenue simply means being shown in commercial movie theaters. Isn't there also a proviso that says that revenue does not mean profit?
Correct, and we don't know that the movie made any revenue at the Roxy. We know that it premiered at the Roxy. We don't know if the premiere was constituted being shown in a commercial theater.
Counsel, if I may,
Yeah.
the Philadelphia Inquirer, there was a review of the movie. October 1st, 2009, the Philadelphia Inquirer, there was an advertising poster regarding a run in the theater. And then in 2010, there was also another review. Obviously, it was to the public. And just going back to what my colleague said, clearly the 2001 agreement said revenue does not mean profit. What revenue meant when it was shown, clearly was shown 2009 and again in 2010.
And again, I'll direct your attention, Your Honor, to the case that we cite about movie premieres sometimes being four-wall deals that are in fact paid for by the people who are marketing the film. We don't know if the people who reviewed the film
But counsel,
actually
that didn't,
paid.
sorry, counsel,
Yes.
that didn't happen here,
Sorry.
right? Sorry, the plaintiff was paid all of $206, which isn't all that much money, but there's no indication that she paid to have the movie viewed, screened, let me use the right word.
Respectfully, Your Honor, the plaintiff submitted an affidavit which we don't believe is properly considered, the defendant, excuse me, submitted an affidavit which we don't believe is properly considered by the court on a motion to dismiss for reasons that we go into in detail in our brief and based on those cases. So we don't know if the movie made any money. I think if you did consider the affidavit, the defendant admits that she doesn't have proof that the movie made any money. But be that as it may, it's not something that should be considered here. What should be considered here are the allegations that are in the complaint. And those allegations do not establish that the movie generated revenue prior to 2014.
Okay, counsel, we're going to hear from your, from the respondent, and then you'll have a minute to respond.
Thank you.
Thank you.
May it please the court, my name is Stan Goldberg. I'm appearing today as of counsel to Ira Levine, and we represent the respondent. I'll try to be brief. I'll just, first, if I may, correct one fact that was discussed so that it doesn't cause confusion. There were two agreements, but they ultimately, if you read them, they have nothing to do with each other. In fact, they're misnomered all throughout the appellant's brief. The 1990 agreement, the 2001 agreement did not even amend the 1990 agreement. There's no connection, even though they mischaracterized there being one. The only operative agreement is 2001. I just want everyone to know that. Okay. Briefly, the Sony case that was referred to as the four-wall deal. I think this court can take notice that a case involving Sony Pictures and multiple movie theaters that took place 10 or 15 years later just has no bearing on a small indie movie that was shown in 2009. And we say that in our brief. And the final thing, Your Honor, is that one of the main themes of the appellant's position is that courts are bound to give this the most favorable reading, and particularly in a pro se situation.
Well, does there have to have been some proof that there was generating revenue as defined in that 2001 agreement before the statute of limitations could begin to run on suing under that agreement?
I don't believe that there has to be proof because pleadings don't require proof, and this is a motion to dismiss, not for summary judgment, so no one would attach proof per se. However, if you read the complaint, the language of the complaint itself, which is concededly by the appellant ambiguous, but if you look at the language of the complaint in the most operative paragraphs, and if I may, paragraph 9, the movie was released in 2009 and continues to be promoted and sold. In paragraph 10, there's an admission that perhaps this would reset the clock regarding the statute of limitations. In 11, it says, since the movie was released in 2009, defendant has been, and then in parentheses, beginning in 2014, a very convenient parentheses, and is currently promoting and selling the movie. So all throughout this, clearly the judge below, the court below, kept saying 2009 and 2010 within the four corners of the pleading and from nowhere else. And the fact that there's then these sudden insertions from out of the blue as to 2014 with no basis for that date, that just creates an ambiguity. And at some point in their arguments, they said, well, sometimes when a pleading is ambiguous, which they conceded that it might be, well, that's a good reason for a judge to let it move on. Well, we believe otherwise. If a pleading is defective and if a pleading is ambiguous, and this judge read it within the four corners of that pleading and interpreted it in a logical and rational way and determined that 2010 was the outermost date that this cause of action could have accrued, I think the judge had the perfect discretion and it was appropriate to do that. And I think that as a matter of law, it can't be overruled, that judge's interpretation, when it's logical and reasonable. Thank you, Your Honor, unless you have any questions.
Okay, thank you very much, counsel.
Just very briefly, Your Honors, I think that what Defendant's Counsel has mentioned here, that there was a date, 2014, when the movie started to be sold, and it was sold over the internet. It was actually tied to something, to an event, is very important in this case. The other issue that I think is important is that the fact that the complaint is inartfully pled makes some sense because it was pro se, and the plaintiff has stated that the movie continued to be promoted and sold. It doesn't say when the movie started to generate revenue. The only allegation we have of when the movie started to generate revenue or to be sold, which the trial court does use interchangeably, even though they're from the two separate agreements, is the claim that it was sold over the internet in 2014. Our reference to the Sony case was to demonstrate that there are four-wall agreements, there are premieres, there are not revenue-generating events. So if there are no questions.
Okay, thank you, counsel. Thank you both.
Thank you.
The next case for oral argument is Ofek Rachel. I am disqualified from that case, so I'm going to step out.
May it please the court. My name is Jonathan Schloss of the law firm of Schloss & Schloss PLLC, attorneys for appellant Ben Suki. There are three factors which led to the incorrect rulings in the lower court. Primarily, number one, the lower court and petitioner respondent's counsel ignored publicly viewable liens and encumbrances to the tune of about $8 million. Number two, the lower court and petitioner respondents ignored explicit statutory language of CPLR 5206A, even used an ellipsis to delete or move beyond the language that says that property of one of the following types not exceeding $150,000 in value above liens and encumbrances. That's super important language which was deliberately ignored. And the third primary factor which led to the incorrect decisions below was that the lower court ignored the distinction between property owned as joint tenants and property owned as a tenancy by the entirety. Regarding the publicly viewable liens, petitioner before the lower court said, hey, this is a straightforward petition. We have a mortgage, which is true, but it wasn't completely true, in that he represented to the court that that was the only thing that was out there encumbering Mr. Suki's interest. There's no explanation at all in the respondent's brief, and he doesn't even address at all why the petitioner submitted this mortgage and no other judgments or liens, because that was very important to paint a complete picture before the lower court, and just didn't happen. With regard to the joint tenancy.
Counsel, was this
Yes,
a
Your Honor.
foreign judgment that was domesticated in New York?
Yes.
Okay, that's a big one, right? So the petitioners here domesticated a judgment about $5.5 million here in New York, and then sought to attach, because according to the petition, they weren't able to satisfy that judgment. So they started looking around, they found the condo shares.
Understood. I understand why why they
Why
did
do you
this.
think that they had to also list all the other creditors?
Well, CPLR 5236 requires that the other creditors be listed. I understand the argument that that comes later, but the reason why a complete and accurate picture of the entirety of the liens that encumber is necessary now.
Well, let's say they did that. Let's just say they satisfy that CPLR provision. What else did they, why don't you think that they should get their petition granted? I mean, if they satisfy that, what's
I mean,
problematic?
had they informed
Yeah.
the other creditors?
Yeah.
Well, it wasn't just about informing the other creditors, but rather making the court aware of $8 million in liens on a $3 million property, of which is owned by, as a tenant by the entirety.
Right. But the tenant in entirety, correct me if I'm wrong, case law does allow creditors to go after that. It's joint tenancies that you can't. Tenants by entirely, unless I'm mistaken, is subject to creditors to go grabbing that.
You can, but you also have to establish the value. Whereas a joint tenancy, you can do a back-of-the-napkin calculation of here's the value of the property itself. He owns half, she owns half, and subtract the liens. You can't do that with a tenancy by the entirety. I believe that's the Reister case in the Court of Appeals and the McGuire case cited in our brief, that each tenant by the entirety owns the entire estate. And each tenant remains subject to, any buyer of Ben Suki's interest remains subject to his wife's occupancy. The buyer wouldn't be able to occupy it, and also survivorship. And there's a chance that that person who ultimately purchases it may get nothing.
Well, that's why Supreme Court said that they should do it before he passes away, right? I think that was one of the comments that Supreme Court had, correct?
That was a comment that the Supreme Court had, but I don't believe that that was factoring the case law properly, in that petitioner respondents cited cases that pertain only to joint tenancy, not tenancy by the entirety, not a single case. So I understand what the court did. They did a quick calculation, took counsel at face value as to what the liens valued, and came up with a decision. I get it.
You have time in rebuttal.
Okay.
Give me a second, Judge. The mask takes my hearing aids out.
Oh my gosh, sorry.
Thank you. My name is Richard Sarajan Baum. I'm for the co-appellant Meadow Suki. It's very simple, Judge. When I first went to work in the court system for Judge O'Gorman, he gave me a memo that said, we don't grant things even if there's defaults unless there's a prima facie case proven by the movant. I had an appeal, O'Hanlon versus Resnick. Appellate Division reversed the motion for summary judgment I lost, saying the plaintiff did not prove a prima facie case and the motion should be denied without even reading my papers, without regard to my papers. In this case, petitioner's papers have no proof of what Ben Suki's interest is. And without that proof, you can't determine the value of his interest as a tenant by the entirety. If you are married to somebody and you die first, the other spouse gets all of the assets. So if somebody is a diabetic and 70 years old and the wife is in good health and 50 years old, you have to factor in what is the gamble somebody's going to take to buy that interest. And there was no proof on that. And that's why the case that Mr. Schloss and I had was decided in the Second Department, dismissing a very similar petition, because the proof was only what the value of the condominium was, or in that case, a single-family house, in the entirety. Judge Rackhauer made the mistake, if you look at the transcript, when counsel tried to tell her that after, if Ben Suki died, Meadow Suki would own everything and a purchaser would own nothing, Judge Rackhauer said, I don't agree with that. She was acting under the misimpression that if the judgment was sold to a judgment creditor before Bensuki died, then the sale would have to be canceled.
Well, she said she didn't agree with that interpretation of the cases.
Right.
She says a debtor absolutely has an ownership interest in the property. He is the judgment debtor.
Right. But what is the value of that interest, Judge? There was no, the value of the judgment was rejected in Sklar by Gessnetner, which we ask you to follow. The Second Department's decision is you just can't come in and say, this is the value as a whole, and therefore 50% is the value, and that exceeds the exemption. You have to know what the actual value is of what a willing purchaser would pay to a willing seller for the value subject to.
So counsel, if I may, wasn't the real property transfer report used to establish the minimum worth of the condominium at $2.6 million effective 2006?
The condominium was purchased for that amount. Is that your question? Yes.
Yeah, and the only issue really as to valuation is whether the valuation exceeds the $150,000 homestead exemption.
Plus liens and encumbrances, Judge. Plus liens and encumbrances. When you sell the property, you're going to have to clear title. You can't. We made a motion, a 5240 motion for Meadowsuki in addition to re-argument and renewal. And in that argument, we pointed out you have to consider all of these liens in valuing it and subtract all of these liens
at this point in time.
Excuse me?
At this point in time, isn't it a little premature?
I'm sorry.
She asked, at this point in time, is it not a little premature?
No, it's not premature because you have a gatekeeper function of the court to make sure that these sales only go forward if there's sufficient proof to establish that the judgment debtor's interest exceeds the exemption. And in this case, the judge ordered the sale could take place for $150,000 when the proof, and that's part of our 5240 motion, the proof shows if the property was sold for $150,000, somebody buying it wouldn't have enough money to pay off the liens and couldn't deliver clear title.
Thank you, counsel.
Good afternoon. May it please the court. Dan Goldstein of Smith, Gambrell, and Russell, LLP, for petitioner, respondent, judgment creditors. I'll refer to them as the judgment creditors. Judge Gonzalez, you hit the nail right on the head. Everything that is being argued by counsel is premature. What we have presented the court with was a 5206, CPLR 5206 petition. All that requires us to do is sell the apartment, sell the condo unit for $150,000. That's all that's required at this stage. Counsel wants to jump ahead to stage 2, stage 3, stage 4, giving other creditors notice and proving the value of the condo unit. This is all several steps ahead. All that the judge in the lower court has allowed us to do is grant our petition to take the steps to sell the condo unit above $150,000, and that complies completely with
the judgment debtor's interest. I mean, the judgment debtor's share of the condo, right?
Correct, yes.
So it's 50, as from what I can tell, it's 50-50. So.
Correct. Apologize if I misstated. The judgment debtor's interest in the $3.whatever million condo unit, if somebody is willing to pay more than $150,000 for it, it can be sold under 5206.
Right.
There are now subsequent steps that we have to follow under CPLR 5230.
And knowing full well they're going to have a partner in this deal, one way or the other. That's up to them.
That's up to them. That is up to other creditors,
and interestingly,
purchasers.
If they do that and they become the new tenants by the entirety, so that when the other interest owner dies, they get everything.
They get everything. Maybe somebody would be willing to pay for that.
Right.
And there is no requirement in CPLR 5206 for there to be some hearing to determine theoretically if someone would pay this amount and what it would be. There is no authority for that in the First Department. There is no authority for that in the Court of Appeals, that there has to be a hearing before the sheriff is allowed to attempt to sell The property, all that is required, if the plain language of CPLR 5206, all that is required is the sale exceed $150,000, the homestead exemption that goes to the judgment debtor, and the order specific, it could not be any more clear in this order that the sale is allowed provided it exceeds $150,000. Case closed, 5206 is complied with.
And that's why the Supreme Court said you got to do it before the person passes, because if that happens, all bets are off.
If that happens, all bets are off because the Supreme Court was assuming or accepting that it was held in tenancy by the entirety. So that's why I, obviously very much object to the insinuation that that it was a misrepresentation about the tenancy status. That was not at all the case.
Well, that's unlike a joint tenancy. A joint tenancy is very different from a tenancy by the entirety.
No one called it a joint tenancy. No one assumed it was a joint tenancy.
Well, joint tenancy, you can only be, you have to be married to have joint tenancy.
That's correct.
Right.
That's correct.
Counselor, if I may, what was the reason that the judgment debtors gave for not providing the court with the, I believe it was the 7.6 million in other judgments when opposing the petition? What was the reason for not doing that?
It's irrelevant. It's irrelevant because after the sale is permitted, the judgment creditors have to give notice to all of the other judgment creditors, and they can come in and they can enforce their rights, or they maybe decide not to do that. But what's the difference? All that's required is that the apartments sell for $150,000. This argument that's being made that because there's so many other judgment creditors, that because this judgment debtor owes so much money all around that his house can't be sold, so what? So if someone owes $30 million,
that's the best case.
sell their house?
No, the best case scenario is if I'm a judging creditor, I'm going to let you do all the work, and I'll just come in at the end.
Happens all the time.
So it's 5206 and then the
236, where all the other creditors have to get their notice, and having done this once before, the sheriff is not going to sell the apartment without requiring all of the other creditors' information, making sure all those creditors get notice. They won't even so the sheriff is going to require the other creditors, the order requires notice to other creditors, CPLR requires notice to other creditors. So this suggestion that the lower court decided incorrectly because notice wasn't given to other creditors, it's just extremely premature at this stage. And just to go into the background, it's in our brief, but this is a situation where this judgment was entered 6 years ago. There's been zero effort on the part of the judgment debtor to make any attempt to pay anything towards this judgment. And in our view, the judgment debtor has, in bad faith, evaded paying the judgment. I see my time is out, but
Yes,
we
thank
get
you
into
very
that in our
much.
papers. Thank you.
You have 2 minutes.
I would agree that you don't need a hearing. You just need honest representation to the court, of which there was none. If this
Why are
court...
you so worried about the other judgment creditors? They'll get there. They're all going to show up at that point once they get the ball rolling.
If this court adopts petitioner's reasoning, they would
I don't have to
render
adopt the reasoning. I'm looking at the law, right? I'm looking at the CPLR.
CPLR 5206A, which says that you have to consider the value above liens and encumbrances. That language would be rendered meaningless under petitioner-respondent's reading of the statute. Also, regarding Judge Gonzalez's question about the timing, the Guardian loan case cited in our brief says that no, the timing is actually now to contest and pursuant to CPLR 5240, because if it gets to the sheriff's, if the deed gets to the sheriff, then it's too late. That's the Guardian loan case. And lastly, petitioner respondents talk about the equities of this case. On one hand, you have a family living in a marital home with one judgment debtor and one non-judgment debtor. On the other side, you have a zealous creditor who can't find assets, who would demonstrably get zero on a forced sale, misstated law, and omitted applicable relevant facts to the lower court, and appears to be using the judicial process to harass the Sukis, debtor and non-debtor alike. Thank you, Your Honors.
Thank you.
Thank you. The next case for argument is People versus Jones.
May it please the court, Abigail Everett for Appellate Frederick Jones. Mr. Jones was denied his constitutional right to confrontation. On the merits, the testimony of the detective that Mr. Jones's arrest was quote unquote the end result of a conversation with Mr. Jones's girlfriend is exactly the kind of testimony that the Court of Appeals in Stone held was a violation of confrontation. In Stone, you had something very similar that the detective testified that after speaking to the wife, the defendant in that case became the suspect.
Right. In Stone, however, did the Court of Appeals also talk about the curative instruction? Because in this matter, there was a curative instruction.
Yes.
And in Stone, I believe there was a curative instruction as well, right?
Yes, Your Honor. And the Court of Appeals in Stone set forth a very specific standard for analyzing whether the curative instruction was sufficient to cure the confrontation error. In Stone, the court held that they had to look to whether there was other evidence presented to the jury.
Well, first of all, in Stone, it talked about whether the curative instructions must be deemed to have corrected, well, Stone and also Hyde, I guess, corrected the error to the defendant's satisfaction. So first of all, the court here invited the defense input in terms of the curative instruction. Well, let me back up. Is this even preserved? Because I don't believe, in reading over the transcript, I do not believe that I saw any objection by the defense when the detective, I think it was Detective Orlando, when the detective testified as to this. I do not believe that there was an objection. So I'm not even sure how we reached this, as it was not preserved.
Okay, there are two parts of your question, Your Honor. First is the question.
At least.
Yes. First is the question of whether it was preserved by an objection before we get to the question of the mistrial. Starting in the people's opening statement where the DA said he was going to prove this. And
the opening statement is not evidence, which I'm sure the court stated, as we all know.
Yes, Your Honor. However, when the DA said he was going to offer this evidence, right away the defense lawyer objected, and the court referred back to a hearsay objection that had been made previously and overruled him. Then when you get to the testimony that was predicted by the DA, although I'm not sure that it was 100% contemporaneous, there was an objection lodged by defense counsel. He complained that this is insinuating to the jurors that the wife or the girlfriend.
It wasn't contemporaneous. It was after the testimony. It was after the direct testimony, and it was prior to the defense was to embark upon the cross-examination.
Right.
Then there was some colloquy as to that testimony by Detective Orlando.
Yes, Your Honor. But then the court dealt with that on the merits and overruled the objection. Came in the next day, the judge decided, after looking at Stone, that there should be striking of this testimony. So I would submit that that is definitely preserved because the judge ruled on the merits and struck the testimony. The issue of whether or not a curative instruction was adequate to cure this error is a separate issue. Now, on that, the judge, sua sponte, brought up the possibility of a mistrial and said that the judge said he didn't think a mistrial was required before defense counsel weighed in. I would note there was a motion to set aside the verdict after the jury's verdict. And at that point, the defense lawyer said that the curative instruction had not been sufficient, and the judge there ruled on the merits that the curative instruction striking was sufficient. So again, the judge fully below had an opportunity to consider whether the instruction was adequate, and for that reason, we would ask the court to find that it was preserved. On the question of whether or not this was prejudicial, which is a separate issue, the Court of Appeals in Stone said that what you need to look at is whether there was other evidence in the case that would have permitted the jurors to come up with an alternative hypothesis for how the defendant became a suspect that would take away the direct inference that it came from the non-testifying witness. That was the reason the Court of Appeals in Stone held that the curative instruction was adequate.
So was there not other evidence in this case?
There was not, Your Honor. In
Well,
fact,
what about the fact that Zarilla, whatever, positively identified the defendant from the lineup? That was before the jury.
that's not the issue, Your Honor. The question in Stone is not whether there was other evidence in the case. Yes, there's other evidence in this case. The issue is whether there was evidence that would lead the jurors to infer that the reason he became a suspect was based on the out-of-court statement. And in this case, there is not other evidence. In fact, the DA said explicitly that his arrest was, quote-unquote, the end result. There was no, Mr. Zaria, although he identified him later, there was no evidence that the juror could think that Mr. Jones was arrested because Mr. Zaria had already identified him. That's the evidence that the Court of Appeals in Stone is asking this court to evaluate in determining whether or not the curative instruction was effective. And I would point out,
I thought that Stone said for the evidence to be of the type that cannot be overcome by curative instructions, the testimony must be powerfully incriminating.
Right, and Your Honor, I'm reading from Stone now. In assessing whether it's powerfully incriminating, the court said whether there was other evidence presented to the jury that would have enabled them to infer the arrest was not based on the non-testifying witnesses out of court.
Well, given the fact that the testimony that we're talking about in terms of it's Tyrese Diaz, who was the girlfriend, she was not a witness to the shooting. And there was no testimony that she was a witness to the shooting. So any statements or whatever that she would have imparted to Detective Orlando would have been pure hearsay.
Well, I know that's respondent's position, but as we argued
But
in
isn't
the
that
reply
correct?
brief, no, I don't agree, Your Honor, respectfully, because this is a unique case where there was a videotape of the crime on multiple TV programs immediately afterwards. The record shows that the woman who was the sex worker who came forward, the reason she came forward is because this tape was everywhere and it was well known, and the jurors could easily have inferred that that's why. And there was testimony in this case that Ms. Diaz, the girlfriend, initiated contact with the police.
Yes.
There's full reason for them to infer that just as the prostitute initiated contact with the police, Ms. Diaz
But the young lady, the woman, I don't know that. I guess she was a sex worker or whatever. She's the one that's going into the bodega.
Yes.
But I don't think that there was any way that you could confuse Ms. Diaz, who was the defendant's girlfriend, and this woman who was going into the
No,
bodega.
I think I must have been unclear. I didn't mean to imply that they would have. I'm saying that the same reason, motivation that the woman who went into the bodega came forward was because she saw the shooting on TV. So this is, although the girlfriend may not have been an eyewitness to the shooting, she likely saw it on TV, and then the jurors could have inferred that. There's nothing else in this case. The prosecutor argued specifically that his arrest was the end result of information they got from her, from the girlfriend.
It wasn't specific. It was one statement by Detective Orlando. It wasn't, he didn't harp on it during the cross-examination, during the direct examination, nor did he harp on it during summation.
He may not have harped on it, but it was very specific.
Made one comment.
And the DA opened on it and said, you're going to be curious about this, and I'm going to prove it to you. Thank you, Your Honor.
Okay, thank you. You'll have a few minutes in rebuttal.
May it please the court, Rafael Curbelo for the Office of Darcel D. Clark. The defense attorney agreed with the proposed curative instruction and did not object after the court delivered the instruction, nor did he request a mistrial. And for those reasons, this claim is unpreserved. And in any event, any error would be harmless because, as was mentioned in People v. Cedeno, a Court of Appeals case, that in order for an error to be of the kind that cannot be cured with an instruction, it had to have been powerfully incriminating. And Thais Diaz did not witness this shooting. And that's the key difference between this case and People v. Stone. In Stone, it was the defendant's ex-wife who was present at the time that the defendant attacked her then boyfriend. And so she saw firsthand the assault, and there could be a reasonable inference that the information she provided to the police would be incriminating, directly incriminating to the defendant. Here, there is no indication that Thais Diaz personally witnessed the shooting.
I know, but I was thinking about that. Could the jury possibly infer or somehow speculate that the defendant confessed or admitted to Ms. Diaz that he was the shooter? Because there were two individuals, right? He was acting with someone else, but he was the actual shooter. So could it be that he intimated to Ms. Diaz that he was, or admitted to Ms. Diaz that he was the shooter?
It could be, but we know that did not happen. We know from the...
But did the jury know that?
The jury does not know that. But that could be a fair inference. Fair enough. I could see that. But we know that that did not happen. And in any event, there was other evidence in this case, one of which was video surveillance. And in defendant's reply brief, they write that nor does the video sufficiently show the shooter to permit any identification. Well, they can't have it both ways.
Well, the video surveillance showed the individual who was the shooter, who you contend was the defendant, wearing the same type of clothing that was taken from Ms. Diaz at the defendant's apartment.
Correct.
Which was the same clothing, I think, that had like a DNA match or three.
Correct. Correct. It was a rather unique jacket with a zipper on the left sleeve. The zipper tab is made out of metal and connected to a metal ring. And for a fraction of a second, at the lower left-hand corner of the video surveillance tape, I believe it was at time 5:54 a.m. or thereabouts, you can see this glint of light right there at the upper left sleeve. And you kind of wonder, what is it that was about that sleeve that would reflect light? And sure enough, there's a zipper tab connected to a metal ring right there. And plus the DNA, at best, it established or corroborated that it was the defendant's coat. At worst, it established that he wore that coat, at least.
So can we engage in a harmless error analysis where you're talking about the confrontation clause?
Yes, Your Honor. Yes, Your Honor. This evidence, Thais Diaz could not have given evidence that was powerfully incriminating. And if you can't look at it in a vacuum. Here you've got video surveillance. You've got eyewitness testimony. You've got DNA. You've got the cell site data. And then...
Yeah, the strip club, right?
You have, yes, the scanning into the strip club. And to some degree, you have his flight to North Carolina, and the jury was free to weigh it as it deemed fit. There could be an innocent explanation, or you look at it in light of all of the other evidence, and the jury was free to give it the weight that it deemed necessary or deemed appropriate. So you have the DNA, the eyewitness identification, the video surveillance, the cell site data, the flight to North Carolina. There's no way that you can say that it was Thais Diaz's telephone call to the police that was so powerfully incriminating that it could not have been cured with a curative instruction. And if there are no further questions, I would ask that the court affirm the judgment.
Okay. Thank you. Ms. Everett?
Your Honor, the harmless error standard and the constitutional error under Chapman is there no reasonable possibility that this confrontation clause error affected the jury's verdict. I would point out that the trial judge, in fairly unusual statement, did say at sentencing that he personally had some questions about the jury's verdict. This is not an overwhelming evidence case. In fact, under the constitutional harmless error standard in Chapman, this court should not even be considering harmless error unless the case is overwhelming. And we have to keep in mind that this is a case where this eyewitness came in and did not make an identification.
He was credible. I mean, he could be considered to be credible because he did not. He stated that it was 2 years later and he could not make an in-court identification. But he did identify the defendant at the lineup.
He did identify him at the lineup, but there are also a lot of weaknesses in the DA's case. For example, the DNA. There were 3 people on the coat. He wasn't even a major contributor. He's just one of 3 who could have been on it. You cannot, I know that the respondent has provided the videotape to this court. If you look at it, you cannot make out any facial features. You cannot identify the clothing as specifically related to this. You cannot see an orange tag on the jacket. The photo's been provided to this court.
The jury viewed the video surveillance, is that correct?
Yes.
The jury did. So, I mean, the jury saw all of this, and the jury made a determination, and they found that the people had proven the defendant's guilt beyond a reasonable doubt.
Yes, but obviously in every case where there's a constitutional error and the court finds that it was not harmless, the jury has reached the verdict of guilty. So the question is
Yeah, but can you actually say that if in fact there had not been a statement that the end result was, the end result after speaking to Thais Diaz was the defendant's arrest, can you actually say that that information was so overwhelming that it tainted the other evidence in the case of the defendant's guilt?
Well, the jury certainly focused on Detective Diaz's claim that he got these clothes from her. They asked to hear a rereading of his entire testimony on this point. They asked numerous questions, or at least 9 jury notes. I would also submit the respondent talked about that the evidence, we know from the evidence, in fact, that my client did not confess to her, but we also know from the evidence that indeed she did see the video on TV, and that is why she called, and that this was a reasonable inference for the jurors to have drawn, just as defense counsel complained below, that it appears that the defendant's girlfriend has told the police that he's the murderer. Thank you, and I ask for reversal.
Thank you very much. Thank you both. The next case for argument is Agramonte versus Local 461. Judge Kennedy is disqualified from this case. Thank you. Good afternoon.
Good afternoon, everyone. My name is Arthur Schwartz, Advocates for Justice Chartered Attorneys for the appellants. I want to start, I have to start with the holding, I mean, I guess it was the holding that the judge dismissed the case based on, which was that the court didn't have jurisdiction under a case called Martin v. Kern. For 100 years, as recently as a case, and 43 years of which I've been litigating union democracy cases, in a case as recently as a case I litigated in June, and which is on appeal before this court, as Professor Summers said in his seminal article, Judicial Regulation of Union Elections, the New York courts have seen scores of lawsuits addressed to union elections, and a great majority of the suits are in fact brought prior to voting. The New York courts have not hesitated to correct the process in mid-course. In our brief, we cite at least 26 cases on pages 10 to 12 of our reply brief, which include appellate division cases and Supreme Court cases where the courts have involved themselves in union elections. And of course, this court in Lasande versus Seabrook wrote, union constitutions and bylaws constitute a contract between the union and its members and define not only their relationship, but also the privileges secured and the rights of a union member to serve the union's compliance with its constitution and bylaws is thus enforced by the courts of this state. And in that case, which involved the correction officers union, the court cited a number of cases that involved other union, the appellants, the appellees try to distinguish Lasande because they say that the correction officers are not only a union but a not-for-profit corporation, which is not really what this court held, because it cited in making the statement I just read.
Counsel, I'm sorry, I lost you. Where did the court say that they didn't have jurisdiction? It said that you didn't properly plead that each individual union member authorized or ratified the allegedly unlawful actions.
Well, it was a motion to dismiss, so he found that, to me, that's
You didn't properly plead. I read it that you didn't properly plead, again, that each individual union member authorized or ratified the unlawful actions.
Well, Judge, to me, that's a question of jurisdiction, because in a union election case, you will never have all the, even if there's one person running with no support, you will never have all the union members supporting what somebody is complaining about. It would be impossible to plead. This is like I messed up and didn't plead that all the members of the union endorsed this. There was a slate of candidates running against the incumbents. There's no way in a union election case you're ever going to have all the members of the union ratifying what the leadership does, not the leadership, I'm sorry, what the election committee does in how it's running an election. It would be impossible. So basically Judge Perry is saying that you can't litigate a union election case because you can't plead that all the union members agree with the position taken by the election committee in that election.
So Judge Perry cites our case, the First Department case, Charter Communications versus Local Union number 3, wherein we also cited Martin, right, versus Current. We were talking about in an action where you talk about common law tort and breach of contract and violations of the common law of elections in New York.
But that, first of all, that wasn't about a union election. That happened to involve a contract between a union and an employer. We are talking here about a union election where the contract is the union constitution that, going back to Poland versus Kaplan in 1920, the Court of Appeals said members may sue to enforce the union's constitution and bylaws, which is why I was able to cite over 35 cases to the court between 1920 and the present, in fact, as recently as this year, where the courts have found that they can intrude into union elections based on a violation of the contract. And the Court of Appeals in the Madden case, which is important because the defendant said, Martin, we kicked this guy out of the union, it violated the union constitution, but the court is barred by Martin v. Curran from addressing this question.
But exactly, and Martin v. Curran talks about the legislature, and it specifically says, for better or for worse, the legislature has limited such suits against association officers, et cetera.
I don't think, Judge, if you go to, there's a lot of people talk about what the legislature did. Look at the General Association's law. It says, an action or special proceeding may be maintained against the president or treasurer of an association to recover any property or upon any cause of action for or upon which the plaintiff may maintain such an action or special proceeding against all associates by reason of their interest or ownership or claim, either jointly or in common, or their liability either jointly or severally. And the courts have repeatedly found, why after did it take until the Martin case is 1950, it's 2022. There has been maybe one court out of 40 courts that have considered union election cases that found, and that's the one case that Judge Perry relied on, that found that the courts, that you can't sue over a union election because you can't plead that all the members ratified what the election committee did in that election. why 70 years later are we in a situation where the courts, in fact, what the New York courts did was relied on by the Congress when it passed the federal statute, the Labor Management Reporting and Disclosure Act. Professor Summers' article was basically written in 1959, which was when Congress was considering that law, to explain to Congress what New York courts, which were the most active courts in intervening in union elections, did. Because
So, but Martin is a Court of Appeals case. Are you suggesting that we should not follow the Court of Appeals in Martin?
am I suggesting what?
That we not follow Martin, that we no longer follow Martin.
First of all, Martin
It's the Court of Appeals.
Martin doesn't say a word about. Martin was an intentional tort. Martin was about a libel. There was a libel in the union newspaper. So I'm not suggesting you don't follow Martin. Martin was about libel. In 1959, 9 years later, the Court of Appeals said that if there's a case involving a violation of a union constitution where someone is expelled, not only can you sue for injunctive relief, you can sue for damages. We're going to call this an exception to Martin. And then there were later cases where the Court of Appeals, we cite in our brief well, first of all, courts have found, then made an exception for negligence, including this court in Salame versus Tucson. Unintentional torts became an exception. And I don't see how that fits into the General Association's law either.
Okay, counsel, we've given you an extra few minutes, so let's hear from your adversary and you'll have some time in rebuttal. Thank you very much.
Thank you. May it please the court, my name is Hannon Kolko from the firm Cohen, Weiss & Simon, and we represent the Appellate Local 461. I want to address a number of points that counsel raised. First, he told you that there are 36 cases where courts were permitted to intervene in union affairs. And with regard to that, I want to direct the court's attention to a First Department case called Well-Built, 719 NYS 2nd 213. The skip site is 217. That's a 2000 First Department case. It talks about what it means for a case to be precedent. And in Well-Built, this court said that a case is precedent only as to those questions presented, considered, and squarely decided. That's 719 NYS 2nd at 217. All of the cases that are in counsel's brief, none of them addressed the precise issue before Your Honor here, whether in a contract claim, and Martin v. Curran by its terms applies to contract claims, whether in a contract claim there is some sort of exception where it is a union constitution and a union and election. So none of those cases are precedent because they don't address the issue before Your Honors today. The single case on point is the Third Department's 1982 Mountier case, where the court squarely held that where a person is suing a union in connection with an election, Martin v. Curran applies. And what does Martin v. Curran say? It says two critical things. A, it says that where the defendant is a voluntary unincorporated association like this defendant here, and where there is a claim of either contract or tort, the plaintiff has to plead and prove that every single member authorized or ratified. That's the law, Your Honors. That's the law. Now, counsel talks about policy, but I direct Your Honor's attention to the 2014 Court of Appeals decision in Palladino, 23 New York 3rd 140. And that was another case where there was an attack on Martin v. Curran. And the appellant there raised similar arguments. And at page 152 of that decision, the court said those are arguments best addressed to the legislature. If the Martin v. Curran doctrine is going to be narrowed or eliminated, It is the legislature that's supposed to do it, and Your Honor asked that precise question. That was exactly the right question. What counsel is asking you to do this afternoon is the job of the legislature. Now, I want to talk about the Lasande case, which is a First Department case. When you read that decision, you will see that literally in the first sentence, it says that the defendant union is a not-for-profit corporation. So unlike the defendant union here, which is undisputedly a voluntary, unincorporated association, the defendant in Lasande was a not-for-profit, and not-for-profits don't fall within the ambit of Martin v. Curran. So the Martin v. Curran defense is an affirmative defense. The reason it wasn't addressed in Lasande is A, because the defendant didn't raise it, but B, because it was a defense not available to that union because it was incorporated. And then finally, I want this court to remember that in March of 22, in a case called Catania versus Woodruff, it was another case where you had before you whether to apply Martin v. Curran. And the court found that Martin v. Curran barred the claim, and it made two critical points. One, Martin v. Curran applies to contract claims, and B, policy arguments are best addressed to the legislature. If you have no more questions, I appreciate your time. Thank you.
Thank you, counsel. Mr. Schwartz?
Yes, I'll try to address a couple of points that my colleague made. First of all, he says a case isn't precedential unless an issue is considered. Now, I can tell you that the two of us just litigated this case that's up here, where Judge Frank issued an injunction stopping an election. They raised this defense, and Judge Frank didn't write about it. That doesn't mean that when you see a history of, well, and it isn't 36 cases involving union constitutions. It's 36 cases where the courts intervened in union elections.
But counsel, if I may, are you asking us to create a new exception? And if so, what is the exception to the Martin rule that you wish us to create?
So I'm not saying that you should create a new exception. I'm saying that the courts have always treated election cases going back, even within the years immediately after Martin, where there is a union election going on, where there's no other remedy, which is what the court also talked about in the case involving the expulsion I'm sorry, my brain isn't working, in Madden. In the Madden case, the court did talk about a contrary result would have far-reaching consequences if one wrongfully expelled had no redress. Little more would be needed to stifle democracy in unions. If a union can run an election, a union election committee, not the whole union, can run an election that is being run contrary to the Constitution, and the person can't come to court to try to stop that or to appeal it afterwards, then union leaders would be free to do whatever they wanted despite whatever exists in the union constitution. And there often is not any other remedy other than to come to court, which is why people come to court to address it.
Could you just address very briefly, if I may, the timing of the election? Because I understand that a letter was written to the General Counsel of DC 37 objecting that the elections weren't being held in February, but rather being held in June. But later on, when the election was conducted in February, there was an objection by the petitioners. Am I misunderstanding?
That's not what happened. When the same group of people who didn't have right to vote, they had the right to bring charges and remove the president of the union, which is kind of a bizarre. You can remove the president, but you can't vote on the next one. They brought charges. I was their counsel in the case. They brought the charges, and I wrote to the general counsel saying, is there a president? Is there going to be an election? The Constitution says February, but it's always for 30 years. And I attached all the union election notices going back to 1990. It's always been held in May or June. What is the plan? And then the next thing, she did not respond to me. Then the next thing, oh, she said to me, can you show me notices of the election? So then I sent her the notices, sorry. And then the next thing people knew, there was an announcement in the mail, nominations are going to be on February, whatever the date was. And then we objected and sought a temporary restraining order, which had an interesting history because Judge Perry was granted it and another judge, Judge Ramser, didn't grant it, and the election
The
went
answer
forward.
is that you got what you wanted, right? You wanted the election to be held in February.
No, we didn't want the election to be held in February because the members, the elections were, we wanted the election to be held when people were working as lifeguards. In February, there were only 35 people out of 1,200 members who were working as lifeguards. So having the election in February, which we think was done because that group had exercised its muscle and removed the president, was done not because, all of a sudden they discovered the Constitution of the Union, which had been there all along. They decided, let's do it in February where we can say, nobody gets to vote except 35 people out of 1,200. That's what we allegedly said.
Counsel, thank you very much. And we will take another look, I'm sure, at the briefs and all that you submitted. Thank you very much and have a good afternoon. We're going to take, as I indicated, the case out of turn, D. Gilmay versus New York City Transit Authority, and we just have the appellant on that case. That's because Judge Kennedy is also disqualified from this case, so thought it would be easier.
May it please the court.
Good afternoon.
Tim O'Shaughnessy from MTA Legal, or appellants. As to the bus driver's negligence, plaintiff's expert, Mr. Belize, identified only that he should have moved into the left-hand lane earlier than he did, but the video shows that he could not, and Mr. Belize did not explain how he could have. In short, as we explained, he had to edge over because he was suddenly confronted with the plaintiff's car in the bus lane,
But there was also testimony that because there were hazard lights flashing on the emergency vehicle that the plaintiff was driving, that they had to respond to that in emergency. So whether he had to sit and wait for him to move the car, do something, I mean, he did notify him that by the flashing lights that he was there. He was supposed to respond to the emergency situation.
We see that as irrelevant, Your Honor, because he did attempt to move into the first traveling lane as well as he could and made reasonable efforts to move into the lane.
Yeah, but he didn't make it, did he? That's why he ran over the plaintiff's foot.
Well, the plaintiff's expert did not say he should have stopped, and that would be completely unreasonable.
Do you need an expert to say that if you see a pedestrian standing there in your lane, that you need to stop? I don't know that you really need an expert to say that if you see a pedestrian, you should stop before running them over.
Well, that brings us to the Rucker and Splain cases, Your Honor. What the bus driver saw was that the plaintiff was behind his car with the trunk lid open and doing something in the trunk. And he remained there, the plaintiff, until, and even a little bit after, the front of the bus passed the back of his car.
Didn't your own investigator at some point testify that in the face of an emergency vehicle with its lights on, the bus driver here, was obligated to wait until he could safely proceed? So, I mean, that's what I asked you before, but I forgot it was your own testimony, your witness's own testimony.
No, our investigator is not an expert on the law, Your Honor.
I understand, but I sort of, I jump upon what Judge Weber said. I mean, do you need an expert to say, and your person said, maybe he wasn't an expert, but he was your witness, that, he had an obligation to wait until he could proceed safely, which obviously he could not do in this situation, which is why we're here on this case.
Well, then we come to the question or our argument that plaintiff's actions were the sole proximate cause. Plaintiff was in a position of safety behind his car with,
Well, they assessed him 80/20, right?
I'm sorry?
They assessed the plaintiff 20% liability for this, correct?
The jury
The jury assessed 20%
Oh,
liability.
they did. They did find that he was negligent, and they did
Yeah, so maybe
find,
not solely, look, the way I look at this record, unless I'm reading the wrong record, it's a straight-up jury question for them to decide what happened. I mean, they had all the evidence in front of them, and they, not finding sole proximate cause, but they did hit him with 20% liability, so.
well, which is to say, they did find that his actions
hit
were,
him, excuse the bus.
his actions were a proximate cause. And there's not a whole lot of question about what happened in this case.
No, there isn't.
The question is the question of the legal ramifications. And plaintiffs, in the Rucker and Plain and other cases that Rucker and Plain goes to negligence of the driver, but we cited many cases on the
So
sole
you're saying
proximate
as a
cause.
matter of law that you should have prevailed?
Yes.
Oh, okay.
Yes, we cited many cases, Your Honor, in which plaintiffs were non-suited by the appellate courts because they were in a position of absolute safety, and the normal and logical thing for them to do would have been to wait and not place themselves in a position of danger.
Well, I think, as I said, that your investigator said your guys should have waited, so I'm not sure that that's a matter of law. In any event, we will take a look at it. Thank you, Mr. Shaughnessy, for coming.
Thank you, Your Honor.
Have a nice afternoon. Okay, the next case for argument is Herrero versus 2146 Nostrand Avenue. You're not. Good afternoon, counsel. You may begin.
Oh, good afternoon. May it please the court. My name is Dominic Zafante from Eric Feldman's office. I represent the defendant, Appellant Shawmut. Not a complex appeal here. The lower court should have granted defendant's motion to renew based upon the deposition testimony, where the deposition was taken after the motions for summary judgment, the initial rounds of summary judgment were submitted. It's evidence that didn't exist when the first set of summary judgment motions were submitted. The note of issue was vacated, and further depositions were conducted. And it's evidence that really bears directly upon the issue of whether.
But couldn't you have asked this witness, Mr. Amen, I think was his name? Couldn't you have elicited this testimony from him the first time he testified a couple years earlier? What did you have to wait a couple years later to get this testimony from him?
Your Honor, it's not my witness. So I know it's another defendant.
But you had an opportunity to question him, right?
Yes, Your Honor. The questions were asked in a different way. The same exact questions weren't asked. Be that as it may, the testimony is relevant. There's no question that the testimony is relevant. And this court has very broad interest of justice jurisdiction to consider evidence like this, especially consider that discovery wasn't complete. The note of issue was vacated, and this second deposition was taken while discovery was active.
Well, I mean, it was vacated because, who do you represent now?
I represent Shawmut, Your Honor.
So Shawmut's the one that brought this third-party action later on, and because the new party was in, everybody gets to do their depositions again. So everybody, comes up with new questions. So we've all been there and done that.
Yes, Your Honor.
And you're not supposed to ask the same questions. You just have to ask new questions. So, you brought this person in. I mean, you brought this new party in, and then everybody got to ask questions again. So it seems, you could have asked this question the first time around. That's why the note of issue got vacated.
Yeah, Your Honor. Again, whether or not it's considered newly, evidence that wasn't available when the prior motion was made, I don't believe it's dispositive here because this court has broad interest of justice authority to review. And I think in the interest of justice, on these facts, the testimony bears directly on the sole proximate cause defense. I mean, the issue on the sole proximate cause is whether Mr. Herrero was aware that he was expected to use his employer's scaffold. And the testimony on the second deposition was that, did you ever tell him he was supposed to use Donaldson's scaffold? He says, yeah, I told him every single day, if you need to use a scaffold, you have to use our scaffold. Again, I'm not asking for summary judgment here. We're just looking for an issue of fact, a chance to argue this before a jury. I'm not looking for dispositive relief in our...
I understand.
Are there any other questions?
Any questions? Okay, well, why don't we hear from the respondent, and then you certainly will have an opportunity to respond to that. Thank you.
Good afternoon, may it please the court. My name is Neil Finkston here for the plaintiff respondent. First, turning to the purportedly new evidence, Mr. Emmon was a witness that the appellant had questioned in 2017. They relied on his testimony when moving for summary judgment. There was never a question about the insufficiency of the deposition.
Well, but we know, like, this is standard procedure. A new third-party action gets brought, we start all over again with the deposition.
Yes, Your Honor, which is precisely why relying on it isn't, in our view, an interest of justice question. It's perhaps just questioning the witness more thoroughly in 2017. Trison, the fifth-party defendant that was the only party that questioned Mr. Emmon in 2019, they were brought into
I got a question.
2 years later. Yes, Your Honor.
The second deposition, did we finally figure out who owned or who was responsible for that Baker scaffold?
The question of ownership is still an open one.
That's not your problem, right?
Correct, Your Honor, which is
On a
why...
240 claim, all we know, unless they're disputing, he fell off the scaffold.
Yes, Your Honor, which is why, in part, plaintiff was granted summary judgment, which was affirmed by this court.
So it becomes amongst the defendants as to who's going to have to pay because they don't know who owns the scaffold. But for your client purposes, he fell off the scaffold.
That's our position, and that's why liability on summary judgment on liability was granted. As for the substantive argument that's being raised by the appellants, it really boils down to a speculative interpretation of one issue, one answer given on page 1737 of the record. Mr. Emmon testified that he had informed Mr. Herrero that if he ever needed a Baker scaffold, he should take one downstairs where JD Consulting had their equipment. In our review, saying that if he needed one, he should go get one from the storage closet is not sufficient to satisfy case law requirements as to an expectancy to use a particular safety device. Again, there's no question here that Mr. Herrero is using the appropriate safety device. The only argument that's being raised as to ownership with respect to use of scaffolds at the site, the evidence is clear that there was no prohibition about using the assembled scaffold that was there. Mr. Emmon couldn't identify any instances where he told Mr. Herrero not to use other contractors' devices. In fact, the evidence shows that JD Consulting workers were using the equipment of other contractors. So in total, this is really, as Judge Owing pointed out, this is the plaintiff's summary judgment on liability. The defendants, the appellants, have relied on nothing more than speculation to try to raise an issue of fact, relying on belated evidence that they could have obtained previously. Unless there are questions, we'll rely on our brief.
Okay, thank you.
Thank you.
Counsel, you have 2 minutes. We gave you 2 minutes.
Very, very brief, Your Honor. Just for clarification on the law does not require that the plaintiff be specifically told that he wasn't allowed to use any tool or method. The law just requires that.
Yeah, that's a good point to make, so that if that scaffold belonged to the company that he was working for, then your argument fails, right? Because we don't know who owns that scaffold.
Well, it's clear in the record that it was not one of Shaw, it was not one of
I don't know
Shaw
if it's clear in the record. If it's clear in the record, it would have been point blank, the first sentence in an argument. I didn't get the sense of that. I think it's still unclear as to who owns the scaffold.
Well, no one identified who the actual owner was.
Right.
People identified who weren't the owner.
Who wasn't the owner?
Yes.
Okay.
But like I said,
well, wait a minute. If that's the case, the process of elimination, then whoever's left standing owns the scaffold, right?
No, Your Honor, because there were other contractors who were working there who probably, it seems under the record that there were
Got
other
it.
contractors who
Thanks,
might have
I
been
got it.
working there who left it. Thank you, Your Honors.
Okay, well, thank you all very much. Thank you both very much. Have a good afternoon. The next case for argument is Sta Parking versus Federal Insurance. Good afternoon.
Good afternoon, Your Honors. May it please the Court. I'm Melissa Brill from Cozen O'Connor, and I represent Federal, the appellant in this case, and responded on the cross appeal. The lower court erred in allowing STA to assert facts here in this case that directly contradict its sworn statements in a prior action. So to go back a bit, there are two policy periods at issue here. We'll call them 1 and 2, and Federal issued excess policies in both policy periods. Under the first policy period during the relevant time, there is no coverage, and under the second policy period, there's a Lancer.
So when you're talking about the other case, you're talking about the Lancer case, right? Is that the other?
Correct. Well, the inconsistent statements were made both in the Lancer case and in the underlying case related to this coverage matter. So that in that case, the plaintiff and defendant worked together to get a judgment, and to get that judgment, they asserted the same facts, that all of this happened in policy period 2.
But haven't we have already decided, I mean, this court in the STA versus Lancer appeal that, that in fact, we said Lancer got off the hook because there was an exclusion if you knew about the damage, if STA knew about the damage, and we found that there was evidence in the record that in fact STA knew about the damage before Lancer, the policy number 2 went into effect. So isn't that now, that's the facts? I mean, so whatever you said before or argued before, that's what we found.
Correct, Your Honor. I do agree, and I think everyone probably at this point agrees that the property damage happened in policy period 1. The problem here is that STA should be prevented from arguing for coverage in policy period 1 now because it made judicial admissions to the contrary and because of judicial estoppel. So it should be stopped.
Wait a second. You just said, unless I didn't hear it correctly, that you're saying that the damage happened during the first policy?
I believe that is what this court found, yes.
Yeah, and that you're saying that they should be judicially stopped from arguing that because of what happened in the second policy.
Because, for 2 reasons, Your Honor. One is that STA asserted and swore over and over again in the underlying case to get the judgment in this case that it is trying to enforce that this property damage happened in policy period 2. And in fact, the judgment itself incorporates the trial court's findings that the damage happened in policy period 2. And in our briefs, you will see that in addition, in the Lancer case, STA asserted at least 13 times that we cite from the record that this property damage did not happen in policy or period 1. They did not know
but they
about
lost on that. I mean, that's very nice that that's what we said, but this court already said, well, we don't find that, and that's why we made that decision. So that doesn't matter anymore. Doesn't our decision trump their arguments below? I mean, that was what they argued, but now we found that they're wrong. So they're wrong, unless the Court of Appeals tells us we're wrong, but I don't think they've done that.
Yes,
yet.
Your Honor, I agree
In
that
this case.
I agree that your decision trumps, and that in fact, I acknowledge that the property damage happened in policy period 1. The problem is that you cannot use the courts to try to get, and I will say that the reason I believe that STA made the argument that it happened in policy period 2 is because they did not, I mean, yes, in policy period 2, is because they did not have primary coverage in policy period 1.
I get it.
So they went and swore over and over again that this property damage happened in policy period 2, and when it was found that, in fact, they knew very well that it happened, the court found not only that the property damage happened in period 1, but that STA knew it happened in policy period.
So what is it that you want us to do? We've already, I'm not understanding. We agree with you because we already said that it happened in policy period 1. So what is it that you want us to do?
The whole, before you go answer that question, just to jump on that, you know, it didn't happen under policy period 2, right? That's what we said. It didn't happen during policy period 2, even though the plaintiff was swearing, even the policyholder was swearing up and down that it did happen in policy 2. So essentially, we rejected that argument, and we said, no, it didn't happen under policy 2. You're saying just by the fact that that's what they swore to, that now they should be held to that as judicial admissions or whatever, collateral stop. I don't know if there's collateral estoppel here, but in terms of that should be held to that. Well, we rejected that position that they had, right? So that why should we now say that they can't argue on this one saying, no, Supreme Court finding that everything says it happened in the policy period, the first policy period, because we rejected it. So that's a finding against them, rejecting their arguments.
That's a good question, Your Honor. And the answer is because the way that the judicial estoppel decisions read are that if there is any benefit, if STA secured a benefit from making that argument that this loss happened in policy period 2, when in fact it happened in policy period 1, then they should be judicially estopped.
They didn't get a benefit. What's their benefit?
So there were two benefits. One benefit is that they got a $3.4 million judgment.
Or they're never going to be able to get any insurance coverage on.
And then the other benefit is that in that case, in the Lancer case, STA, because it argued that the property damage happened in policy period 2, they received a summary judgment ruling that they were entitled to their defense fees because there was a potential for property damage in policy period 2. That is a benefit that they received.
You're talking benefit in a very loose term. To me, was it a real benefit or was it just an amorphous benefit? Because the way we stand now in this current litigation posture, they got nothing. They're going to get, if we agree with you, they end up with nothing. There's no benefit on the second policy, and we're going to kick them out on the first policy, based on the argument that they're now. I don't want to use the word estoppel, but because of the judicial admissions.
I do believe they should be bound to the judicial admissions they made in the
but if you're acknowledging that the damage occurred in the first policy period, how can we ignore that? You're asking us to ignore that? I mean, that.
Yes, Your Honor, I'm asking you to stop STA from making that argument because they've already made contrary arguments and in fact benefited from that argument, not in an amorphous way, but collected damages.
Okay, are there any more questions? All right, why don't you have a seat? Let's hear what STA has to say and you'll have an opportunity to rebut. Thank you. All right, so now what's your argument today? What's your position this afternoon?
You got a third policy?
Quite a mess.
Yes, I agree completely. May it please the court, Your Honors. Good afternoon.
So are you stopped because you took a different position at some point, which we know, but we also know we didn't agree with you and you lost on that. As a result of which you also lost the benefit of the Lancer policy, and according to one of the decision you're appealing from, Judge Leibovitz found that you also don't have a right to the Chubb policy on the second policy period because of the exclusion. That's correct, right?
That's all correct. I also
But then he also said you're good to go on the first policy.
Right. The Chubb, you get the Chubb benefit, but not from the first dollar.
That is all correct, and we agree with all of that. I just want to clarify one thing, though. There was absolutely no benefit to STA, even though we got the defense, because that was based on a different. That wasn't based on any kind of sworn statement. That was based on the complaint and that action, and the pleadings. The pleadings alleged.
You're talking about Lancer now. You're talking about Lancer.
No, actually, well, I'm talking about these judicial admissions that they're
Yeah,
calling, these
right.
sworn statements. There was no benefit that STA ever received. There was the decision where STA got the defense, Lancer was ordered to defend STA, was based on not a sworn statement of STA, it was based on the complaint in the E77 owner's action, which alleged that the damages occurred during the second policy. It was based on the complaint, because the defense and identification, as everyone knows, are two different duties and then based on two different standards. STA lost the identification hands down, as your honors all know.
So, my problem is the judicial admissions argument that they're raising here. Okay, okay, I get that. But the flip side is that there is now, admittedly, on the insurance company's position is that, yeah, we know that the damages occurred in the first policy period. I can't help but how do I get around? They're saying it doesn't matter because now we're going to hold them to the judicial admission, so it doesn't matter that the first policy coverage kicks in because the damages happened in the first policy. Too bad. They took the other position. Something doesn't strike me as correct there.
They're asking the court.
Am I wrong as to what that's their argument, right?
Yes, that's their argument. They're asking the court to overlook the facts is what they're doing. The facts are...
Not overlook, ignore the facts. It's like, forget it.
Yes, Your Honor.
Oh.
If I may, just on the cross appeal, the judge, the lower court erred, we believe.
You're still taking up the second policy after all this argument? You're cross appealing the second policy?
Actually, this is about the first policy.
Oh, okay.
This point is about the first dollar basis that we have asked the court to find that Chubb is responsible for. Based on the language of the Chubb policy, and actually, the Chubb policy references an underlying insurance policy of Burlington Insurance Company.
Right, there was a gap in the insurance.
It references the gap in the Chubb policy. It shows that there's going to be a gap. And what the language of the Chubb policy says is that they're going to be responsible to pay anything over the underlying insurance.
Right.
But there's no underlying insurance for four or so months. So based on
that's because you didn't comply with the policy to continue to have the underlying insurance in force. So then why should they now be first paid when you didn't do what you're supposed to do under the policy?
Because Chubb had the...
Don't ask me how I understand this insurance stuff. This stuff rolls in my head like a nightmare.
Chubb knew they issued this policy, okay, it wrote it into the policy, knowing that there was going to be a gap, but never came back to Sta Parking to cover that gap, to purchase other insurance. STA had a reasonable expectation here that Chubb was going to cover if something happened during that period.
But wait, I don't think it's Chubb's obligation. It's your obligation to maintain the basic level of insurance. I don't know how you missed out on that. Maybe you have a malpractice claim on that. But be that as it may, the subject policy states that the defendant, Chubb, will pay in excess of underlying limits of insurance, which the policy defines as as the total sum of amounts stated in item 5 of the deductions. And item 5 lists the underlying limits of insurance as $1 million for each occurrence. I mean, it seems to me that the language of this particular policy provides that they pay, even if there is no underlying insurance, from $1 million up, that they have no obligation to cover the lapsing portion of the primary of the policy, that they have no obligation to cover that first $1 million. You were required to get insurance, and you, for whatever reason, did not have that insurance.
Well, the Chubb policy also defines what underlying limits of insurance means, and that's on page 84 of the record. And in its definition, it says applicable and collectible underlying insurance. Okay, there was none here.
But, counsel, it also says the policy further required STA to maintain underlying insurance in full force, and that in the event of STA's failure to comply with this condition, we will only be liable to the same extent as if there had been compliance with this condition. And that goes back to item 5 of the declarations, $1 million for each occurrence.
Yes, I do, I agree the policy says that. The policy says different things in different places, and that's part of the issue here, is that it's ambiguous. It's ambiguous on its face.
Okay, let me hear let us hear from Chubb, and then we'll let you respond also, since you have cross appeals.
Just to make clear, Your Honors, I agree with what you were saying about the policy. It is perfectly clear. It is an excess policy. It provides coverage over $1 million. We cite to 3 different provisions in our briefs on the record between pages 74 and 84, and they are the insuring agreement, the limits of insurance provision, and the maintenance of underlying insurance provisions, and they all make clear that this policy would never provide coverage, or almost never provide coverage before.
You're not primary, no matter how much, whatever they do, you're excess. There's
We are
gotta be an
excess.
underlying, the fact that there's a gap, that's not my problem, that's your problem. That's the policyholder's problem, all right?
That is correct, and the policy specifically states that if STA fails to maintain the underlying insurance, then federal will be liable as if there had been underlying insurance, which means in excess of $1 million.
There was a little bit of discussion, although you really didn't brief it, about the interest issue. I mean, has that, is it true that you don't dispute the motion court's conclusion that Chubb was not liable for interest? Was that finding was based on an erroneous finding of fact?
I do not dispute that, Your Honor. Now, there's a lot of negatives. I agree with counsel on that.
On that
I don't know
issue.
where that came from.
Okay, okay,
Yes.
thank you. Any further questions, or did you have anything else you wanted to point out, or?
No, unless Your Honors have any questions for me.
Okay.
Oh, my God, my head's...
Okay, well, you have, since you have a cross appeal, you have 2 minutes also to respond.
Thank you. I will be very brief. Just on page 79 of the record, which is a page from the Chubb policy, discussing the actual agreement and the underlying insurance requirements. There is another section here, or a paragraph, really a sentence that says, if we are prevented by law from paying on behalf of the insured for coverage provided under this insurance, then we will indemnify the insured. Now, I'm not sure what that means exactly, but...
What would you like it to mean?
Of course, I would like it to mean that Chubb pays first dollar on this policy. And it just it goes more into the ambiguous language in this policy.
Okay, any other questions? All right, we'll take a look at this, and thank you so much. Hopefully, one day your litigation in this issue will end. It's only been about 17.
Somebody will pay on the
about
policy.
17 years, so, keeping us busy. Thank you very much.
Next generation of appellate justice.
Great afternoon.
Next generation of appellate justice.
The next case for argument is People versus Addison.
Oh, wow.
Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, my name is Sarah Chaudhry from the Legal Aid Society for Appellant Raheem Addison. The first issue before this Court is Mr. Addison's challenge to the lower court's summary denial of his Wade hearing. As an initial and overarching matter, it is well established that a defendant such as Mr. Addison, who sets forth a sufficient legal basis, is entitled to a Wade hearing. Mr. Addison did just that here by asserting that the identification, the show-up identification, which was made while he was still in custody, was unduly suggestive. In response, the prosecution merely
That it was confirmatory, correct? It was confirmatory,
The
correct?
prosecution countered that the identification was confirmatory.
And the
However,
court and the Supreme Court underwent an independent review in camera of the grand jury minutes and agreed with the people saying that it is confirmatory.
Your Honor, you're correct about that. The lower court took a look at the grand jury minutes and agreed. However, I would submit that the prosecution had the burden to set forth specific facts and details that would demonstrate the nature, extent, duration of these prior relationships, rather than merely asserting.
Well, the court went.
And what is that based on, Counselor? What you're asserting that they should set forth this, what is that based on?
People v. Rodriguez. In that case as well, the Court of Appeals determined that even though the lower court as well as the appellate department agreed with the prosecution, looked to the grand jury minutes, that was insufficient. That defendant there should have had an opportunity to test those claims in an adversarial
Well, you're talking about a Rodriguez hearing, but again, it's the same thing. The people came forth with allegations stating that there was a prior relationship. It was purely confirmatory. They set forth the grand jury minutes. The court read the grand jury minutes. The grand jury minutes stated what the relationship was, and in fact, that it was confirmatory. So what more would there be?
Well, Your Honor, the grand jury minutes were relied on by the court. However, testimony in a grand jury is not subject to the adversarial process. There was no one.
Why do you need an adversarial process if the witness witness testifies before the grand jury under oath, states that he or she knows the defendant, how he or she knows the defendant, the length of time the witness knows the defendant? Why would that have to be subject to any type of cross-examination? And again, there would not be any cross-examination of papers. Is that correct?
Well, in this situation, if the prosecution had actually set forth the facts so that defendant could take a look at them and counter them, that would be an ability that defendant would have to actually, challenge whether or not the confirmatory exception applied.
But the court did it, and the court is the final arbiter in this instance where you're talking about the request for a hearing or suppression. So the court reviewed the grand jury minutes, reviewed the people's response. I mean, that's enough. Why is that not enough?
I mean, the defendant should have had an opportunity to take a look at what was asserted and actually challenged it.
So what about in a search warrant situation? You have a search warrant. The court does an in-camera inspection of the search warrant affidavit as well as the search warrant itself, and the court makes a determination. The defense has no right, other than in People v. Trump, I guess, to take a look at the affidavit or take a look at the information imparted.
Well, in this, that's a good question, but I can only speak to this.
Thank you. It just came to me all of a sudden.
No, I was running through these permutations as well. I was thinking about, why in buy and bust cases will you maybe sometimes have this level of secrecy? In this particular instance, there's nothing in Mr. Addison's criminal history or even the facts of this case that necessitated that level of secrecy.
I totally agree with you, and that's a question that I have for the people. I don't understand why this level of secrecy was necessary. However, I do not see any of the cases or a review which would lead us to have to question that in terms of making a determination, or the motion court having to look to that in terms of making a determination.
Well, Your Honor, I would bring up People v. Rodriguez again, because in that situation, the people did more there than they did here. The people actually said that the identifying witness knew the defendant, he was very familiar with him, cited to 4 instances where they saw each other, and the lower court took a look, as here, at the grand jury minutes and agreed.
And I would disagree with you, because I would say that there was more presented here because we actually have the actual words of the identifying witness before the grand jury. So I think it's even more than in Rodriguez, because we have the actual words of the witness as opposed to the people stating what the witness actually stated.
Well, in Rodriguez, the court did have the grand jury testimony where the identifying witness, Benito, did testify. And so the lower court relied on that, the appellate division relied on that, but the Court of Appeals took a look at that and said, no, the confirmatory exception is to be construed incredibly narrowly, and that's because it's in derogation of the general mandate that so long as a defendant puts forth a legal basis, they should be granted a hearing. Now, Rodriguez and the CPL provisions arose out of an understanding that the legislature had that misidentifications were a primary cause of unjust convictions. So I wonder in this instance why the people could not provide sufficient facts that would enable defendant to actually set forth factual disputes and allow the court to better determine whether or not the
We can't rely on the court's own review of the grand jury testimony to say that they were, that it was sufficient based upon reading the actual testimony.
I would agree with that, Your Honor, and I would also, just to make one other point, because I know that the
I'm
prosecutor...
not saying that's what, it's more a question than,
Yes.
statement, but.
Thank you. I would make one other point also, which is that the people have cited to a number of cases that appear to indicate that this practice of taking a look at grand jury minutes has been blessed by this court. I stand behind what I've initially said, which is that I do not think that it's permissible to rely on the grand jury minutes, given that it's not subject to adversarial testing. However, I'd also like to state that the cases that are cited by the prosecution merely assert that the court may look at the specific facts set forth by the prosecution and confirm whether the court will allow this narrow exception to apply. That's not the case that we have here. There was nothing here.
Okay.
So as much...
I think we got your point. Let's hear from the people, and you'll have 2 minutes in rebuttal. Thank you very much, counsel.
Good afternoon, Your Honors. May it please the court, Christian Rose for the people. With regard to defendants' challenge to the hearing court's reliance on grand jury minutes, I'd like to first point out that the issue is completely unpreserved, that the people made clear in their response to defendants' omnibus motion that they were relying on the grand jury minutes and pointing the court to the grand jury minutes, and defendants did not object to that. I think specifically with the question that was asked about why was there a necessity for secrecy, defense counsel asked, why couldn't the people set forth facts? I think there's a couple of responses to that. One is that, as to preservation, if this was an issue that the defendant had at the time, this could have been resolved 5 years ago at the appropriate level when the prosecutor could have put forth their reasons for adopting this particular process. And also, I think that it's clear where the relationship is so close as here that any concerns that the defendant might have about testimony that's untested by cross are obviated. I'll just briefly touch on...
Counsel, say that again. I didn't understand that. Repeat that.
The second point, Your Honor, is that
Yes.
I think that the concerns that the defendant is raising about testimony that's untested by cross-examination is even less important in situations such as these, where the grand jury testimony reveals a very close relationship, as opposed to borderline cases where the concerns about risk of police suggestiveness, how close that the defendant actually...
But the defense is arguing that they don't know what the grand jury minutes reveal, what the grand jury minutes contain, because they're not privy to the grand jury minutes, and also because there was no statement concluding, like saying in sum and substance what the grand jury minutes actually stated. So they don't know.
That's correct, Your Honor, but I think that the people were acting reasonably given the state of the law, especially that was in place at the time, pre the discovery reform, where this court had made it clear that it's permitted, that the prosecutor is permitted to rely on grand jury minutes or point the court to the grand jury minutes in order to confirm the existence of a prior relationship. And then also in this case, where a relationship is sufficiently close, the facts that reveal the closeness of that relationship will also reveal the identity of the witness. And so I think that the prosecutor...
So that's the concern you're saying?
That is a reasonable concern for the people to have. And to the extent that this was something that probing the reasons for why the prosecutor acted the way that they did, why the court relied on the grand jury minutes, this is something that should have been raised at the level for the motion court to decide. If there are no other questions, I just ask that this court affirm defendant's conviction.
Okay. Thank you, counsel.
So I'm looking at People versus Rodriguez. There's a little bit of a wrinkle there. It's not exactly as you portray it to be. I think in People versus Rodriguez, it was a store clerk who identified the defendant there. And the Court of Appeals said they looked at the grand jury minutes, and it wasn't exactly clear as to how the store clerk would know or be familiar with the defendant such that it could be confirmatory. And that's where the problem is. And in this case here, Supreme Court looked at the grand jury minutes and specifically said, this is confirmatory because there was enough, as my colleague Justice Weber mentioned, there was enough in the grand jury minutes to establish the familiarity with the defendant. So People Rodriguez, you may be right, but it's a little bit of a distinction there.
Okay, well, if I could respond.
It's great with these iPhones. You can pick up the case right away and take a look at it.
So if I could respond, Your Honor.
Right.
So first, in terms of people.
Am I incorrect in terms of how I played out People versus Rodriguez? It was a store clerk. I saw him come in and out a few times, and then didn't. And then that's what they're saying was a confirmatory ID, and the Court of Appeal said, not so fast.
Well, I think there's a couple of things. One is that the lower court and the appellate division did take a look at it and say it's confirmatory. So while there is that wrinkle where there's not this so-called prior relationship, that's true. But what I see is happening in a case such as this is that the people are relying on the semantics of saying there's a prior relationship.
No, not that. No, not true, because it went to the Supreme Court, said, let me take a look at the grand jury. It did an in-camera review to make sure that it was purely confirmatory, because it checked off all the boxes that needed to be checked off.
Well, we'd have to just, we'd have to rely, right, on what the prosecution is saying or what the court is saying. However, People v. Rodriguez, though it may not be completely factually on point, I think that's a difference really.
So are you saying there's never a time that that the court can ever review the grand jury minutes and make the determination that based upon the grand jury testimony, the court agrees that it's just confirmatory? Because you never get to see them, so when would it ever be okay?
Well, Your Honor, in this case, I would say, and I hope that this is responsive, that good facts shouldn't make bad law. It appears that maybe in this instance, the court is saying, well, I looked at it and it's all fine and it's all good.
What if the appellate court, the appellate court looks at it too? Are you saying that we didn't know what we were reading?
There's nobody's casting aspersions about
well,
that.
I'm not saying casting aspersions, but you're challenging our ability to read what's in front of in the grand jury.
No, but there's a reason why the legislature and why the Court of Appeals has determined that in a situation such as this, claims should be adversarially tested. It's not a matter of other judges.
What I'm not understanding is that the same information could have been imparted in the people's response. So if the people had imparted the same information in their response, what is the difference? Is it because you're able to take a look at it?
Of course, we have an ability to take a look at it.
And to therefore challenge the court's ruling.
Right, so in Rodriguez, you had multiple courts that were taking a look at it and saying, no, I disagree. The confirmatory exception applies. Now, if it weren't for the zealous advocacy of defense counsel, we probably wouldn't have reached that court, wouldn't have reached the Court of Appeals. And that's why it's necessary. That's why we have an adversarial process.
Okay, I think we get your point, and thank you very much for your advocacy, both of you. And with the last case for argument today is the Baker and Molnar cases. Good afternoon, counsel.
May it please the court, Lisa Solbakken for appellants Molnar and Baker. Appellants raised two issues for the court today. Did the trial court err when finding that vested equity that was awarded as consideration for personal services falls outside the purview of New York labor law's protections? And did the trial court err in finding that substantial compliance with a notice provision is sufficient under Delaware law?
So you still have several other causes of action pending, correct?
That's correct, Your Honor.
So, how really does this sound like the type of wages that would fall under the labor law?
So,
based upon the cases that we've decided in the past.
Sure. Your Honor, in August of 2021, the New York legislature passed the No Loophole in Wage Theft Act, which the Lerner Court and our court and most of this, and none of the previous decisions on the scope of New York's labor law had the benefit of.
Well, that was like a secondary reason that the judge, Judge Schechter, found against you, but there was a prior reason also, no?
My understanding was that, well, there was two reasons that she found that the New York labor law didn't apply. The first was that it was a deduction, right? And then the second reason was that it wasn't essentially a wage under True Love. And the No Loophole Act addresses both of those issues. The No Loophole Act makes abundantly clear that all employees are entitled to protection with respect to all wages, all wage supplements, and all benefits. Now, the Lerner Court, Your Honor, when considering this issue, relied on Guerrieri, I don't know if I'm mutilating that name, but relied on Guerrieri that in turn relied on True Love and stated the following: where ultimate value of equity to an employee was dependent, even in part, on the financial success of an enterprise, it is not a wage. So they used this court used the terms ultimate value. True Love does not use the term ultimate value anywhere. In fact, all equity will ultimately, the value will fluctuate over time, and one could argue that even cash, the value of cash, fluctuates over time. One day it's equal to the euro, one day it's below, and one day it's above, right? So the Court of Appeals has never addressed this issue as to whether or not a fluctuation of value should affect whether or not something is a wage, and the No Loophole Act provides that it shouldn't.
But I thought Gurry specifically stated that the definition of wages was excluded from certain forms of incentive compensation.
Well, in some instances,
which are more in the nature of a profit-sharing arrangement, which I thought was and are both contingent and dependent on the financial success of the business enterprise, which I thought was pretty much the situation here.
Well, there's a couple of things there. The first is contingent and dependent, and here we're not talking about anything that's contingent and dependent. We're talking about vested equity. And the second portion of what Your Honor is talking about is something, I just wanted to make sure I'm addressing both. It's not contingent, it's not a deduction, and further, in connection with stating that it's a value, that's not anything that's ever been addressed by the court. The only time it was addressed by True Love was when the court was saying that the actual right to obtain this supplemental wage was something that occurred because you had to hit a minimum revenue for the company.
Right, so isn't that what we're kind of talking about here? We're talking about some type of an incentive, right?
No, it's not an incentive payment. It's something to which they are entitled in all events, Your Honor. There's not, and additionally, I would say that the court in many instances finds that incentive payment, like the bonus in Ryan versus Kellogg, is still covered by New York labor law. So it being an incentive or not isn't really the determinative factor. The factor is it contingent? And I would argue with respect to with respect to equity, if it's unvested.
So isn't it somewhat contingent upon the stock prices?
It's not. The right to the actual stock is not contingent. They will get zero. They'll get a goose egg if the value of the equity is nothing. But that doesn't change their actual property right in that stock, right? So no matter what the value is, they're still entitled to it.
So it could be zero, and your argument is that's still that would still constitute some type of wage.
100%, because there's nothing in the case law that provides that a change. Well, nothing in Court of Appeals case law that provides that a fluctuation in value matters at all. In fact, in this day and age, most startups pay their employees wages through stock, right? Sometimes entirely via stock in a startup company. And so any analysis that would accept stock, no matter if vested, simply because it could go to a value of zero, would divest all of those employees from the protection of New York labor law. And that's contrary to what the court was trying, the legislature was trying to effect in connection with its.
So you don't think that matter of Lerner and Geary support the statement that labor law, Article 6, contemplates compensation that's directly related to an employee's individual performance as distinct from compensation based on the performance of the entire business enterprise?
I think that that neither Gary nor Lerner, to the extent that they're relying on True Love doesn't say that. And to the extent that something needs to be tied to personal services, this is. The equity isn't awarded in connection with a fluctuation in business value, and the equity isn't awarded only in the event that revenues hit a bogey. The equity is awarded full stop in connection with the employee's services.
How does, my question is, you're pointing out the vesting, so that's my property now, so that therefore it's earned, it falls under labor law. How does the fact that the company is able to buy back that reward to you, and it's vested, that they're able unilaterally to buy it back when they did, provide, assuming they dot all the I's and cross the T, how does that affect that analysis? Because my understanding is once it's vested, it's yours and nobody can take that away from you. But in this case here, the company did take it away from them and gave them 0 for it.
Right, and we're fighting about that value.
Yeah, but so how does that come into play? So that how does that affect the analysis of how, well, vesting is my property, it's mine, therefore it falls under labor law, when there's a wrinkle here that the employer can take it back whenever, provided they dot the I's and cross their T's and take it all back.
Right. We would argue that it doesn't matter at all that they could buy it back. If you have a right to it, they can buy it back, and then the question becomes, are they paying appropriate value calculated in the matter contemplated by the party's contract, or fair market value, or whatever it might be in the circumstance of the case. That could be 0, but that doesn't mean that you didn't own the property, right?
Well, you don't own the property because they can take it back.
Well, they can take it back, but they have to pay for it.
But in this case, 0.
And in this case, they say that it's 0, and
yeah, but they have the
it's not.
Right, but they have the unconditional right to take it back as long as they pay you for it, and they pay you 0 for it. So it's, in a sense, your property right is still inchoate, as they say. It's still, it all depends on when the employer wants it back, right?
See, we would argue that it's not, right?
Yeah,
Whether or not,
I get
the
your
reason
argument.
why is because it is what it, like, once that right, and then I'm gonna go back to True Love for a moment, because in True Love, what they were dealing with was a revenue pool that didn't even exist until a minimum revenue amount was hit by the company for that year. So True Love essentially says, listen, you don't even have the right to that compensation or that amount unless we hit a minimum revenue, and that has nothing to do with the individual services provided by the employee, right? So in True Love, that's why that revenue pool or that claim to that revenue pool amount did not constitute a wage. We do not have that here. You do not have to hit it. Now, it can be 0, but that would be more of a fact of life than the fact that you don't have that property, or that you're not entitled to that property.
We've given you a little extra time.
I'm
Let's
sorry.
hear from the respondent, and you'll have 2 minutes to reply.
Good afternoon, Your Honors. May it please the Court. I'm Patrick Shea from Paul Hastings, and I represent Green Tech. The law in the First Department is clear on the wage issue. Only last year in Lerner, this Court held that equity, because the value of it is not tied to what the employee's efforts or services been, but because it's tied to the overall value of the company, does not constitute a wage. In that respect, it built on the earlier precedent that said essentially the same thing in the Geary decision. Both of those are solidly grounded on True Love. True Love said you need 2 things to have a wage. First, it has to be vested and non-discretionary. That is the case here. But second, the value has to be tied to something the employee is doing, because that's the essence of a wage. I am rewarding you with this value for what you're performing. And if instead I'm just giving you an incentive compensation that is part of your overall interest in the company, and that depends on the overall market value of the company, including fluctuations that may allow the company to buy it back for 0, that's a second requirement, and if that's all it is not a wage.
So are these cases and this analysis affected by the No Wage Theft Loophole Act, which was passed, what was that, last year or recently?
Not at all. The only thing the legislature changed was the requirement to say that you can have a wage deduction if it is partial and not total. Obviously, if the legislature disagreed with Geary or Lerner or True Love, it was a perfect opportunity for them to say so, and they didn't do so. So there's, stare decisis is important, especially in the first department, where so many bonuses get handed out and where so many employers rely on the findings of this court. There's no basis for this court to overrule Geary and
I mean,
Lerner.
it sounded like counsel was saying that, at least in part, that the Lerner case was citing the Geary and citing True Love, and that we had sort of gone overboard in our determination, that it didn't really say this stuff in True Love.
Well, it's
Did we interpret, I mean, do you think we interpreted that wrong?
absolutely not. True Love had the 2 requirements. Plaintiff wants to reduce it to 1. This court initially in Geary recognized that both of those requirements were important, and Lerner confirmed that. It's absolutely consistent with True Love. I'd also add, for what it's worth, plaintiffs sought leave to appeal of the Court of Appeals. If they thought that True Love had gotten wrong, leave to appeal and Lerner was denied. And that was an even stronger case for the defendant because you were overturning an arbitration panel.
And what about the notice and the substantial compliance issue, which was just on Baker, I think?
Just in the Baker, let me speak to that. The trial court held that Baker's units were properly called because she had actual notice those units had been called that complied with Delaware law. It relied on 3 key facts. First, Baker knew before the units were called that they were being called for 0 value. She got that in a telephone call that she admits receiving. She was angry about it. She actually went out and hired counsel. Second, Green Tech then made an attempt to send overnight delivery. It sent it via Federal Express to her home address, the only address it had because she had moved on to a different employer. We know from the record for Federal Express, they made 3 attempts with Ms. Baker knowing that the call was coming, leaving door tags where she could have gone and either signed to receive it the next day or picked it up at a FedEx office, and she ignored those, and therefore, essentially, the overnight receipt that Green Tech had attempted was unsuccessful. Third, just out of abundance of caution, Green Tech sent an exact copy of what had been sent via FedEx via email the day that her units were called. And that notice says, your units have been called effective as of the closing.
Well, I'm glad you mentioned that. Going back to the first requirement of vesting.
Yes.
Right. In this case, in my understanding of vesting, when something vests, I have control over it. I get to decide whether or not to dispose of it or not. And in this case here, the plaintiffs did not have control over when to dispose of it. I mean, yeah, it's vested, but it's really up to the employer whether or not to, whether or not you're going to keep it or not.
Exactly. They have a 2-year window.
There's a little bit of a wrinkle there in terms of that first requirement of vesting. So it kind of falls into some sort of different zone, so to speak, right?
Justice Alito, I agree with that analysis. There's a serious question about vesting, and in any event, the second requirement is also not satisfied. So the judge below correctly looked at Delaware law, said substantial compliance is all that's required. For the reasons we've set forth in our brief, I think it's very clear that that is all that's required. And unless the panel has further questions, I would ask that the judgment below.
I have a brief question, if I may. So the call notice was prepared February 17th.
Yes.
The date when it was first sent out was when?
Was on February 24th, after the phone call that same day had been placed to Ms. Jones-Baker.
Was there any requirement with respect to the timing, the interlude between notice and when the shares would be sold, repurchased? The units would be repurchased, I'm sorry.
All that the partnership agreement says on that is that the call has to take place within 30 days of the notice, which it did so here.
But no minimum?
No minimum. And again, the whole point about that is the closing here is automatic because there's no consideration being exchanged. They're being called for 0 units. She doesn't have anything to tender at a particular closing. So it's a closing where no one is going to show up and no one is going to do anything. Plaintiff's objection that the email was received after the stated time of closing, I think, is completely immaterial on that point.
I think your adversary is arguing that those units belong to her even when they reach a zero value, and that if you hadn't repurchased them, they would have had value. And that stocks and everything related to the market go up and down, and you seized the opportunity to purchase them at a 0 point instead of waiting for them to go up again, right?
Well, I think my client's point was, if you've left the company, which Ms. Jones-Baker had and Mr. Molnar had, then you're not really entitled to participate if all the remaining members of the company, all the remaining partners, add value in the future. That's precisely why there is a call option in the partnership agreement to be able to repurchase those units. But you hit on an important point, and that is Jones-Baker received that email notice saying the company has called your units. It specifically said, if you have any questions or concerns, please contact us, call us. Jones-Baker did nothing, and she actually waited 4 years. Ryan, when Jones-Baker left, GreenTech had sustained 5 consecutive years of multi-million-dollar losses. After she leaves, the people who are still left in the company engineer a remarkable turnaround so that many years down the road, many years after Jones-Baker's departure, she then comes forward and says, well, I did get all those call notices, but I have this claim that it was not in strict compliance, so I still own all my units and I want to cash them in order to be able to take advantage of all the value that was created after I left the company. And that's what the trial court's referring to when it says Delaware law does not insist on strict compliance with respect to a manner in which notice is given, especially when it will result in unnecessary harsh results.
Okay. Did that answer your question? Thank you.
Very much. Thank you.
Thank you. Thank you, counsel. Ms. Solbay, you have 2 minutes.
Your Honor, briefly with respect to the notice provision,
Sure.
either we're right or he's right. The Delaware law, we refer this court to PR acquisitions. It's very clear. Even actual notice is no replacement in Delaware, which is a contractarian state, which they love to tell us New Yorkers whenever we go down there. Strict compliance is necessary. Right? They don't get to use that sometimes. It applies to notice provisions, and the law is what the law is there. But to go to your point, Justice Oing, with respect to they still have control over the equity, I'm reading from page 376 in the record, which is the No Loophole Act, where the legislature says specifically that the article is to reflect New York's long-standing policy against the forfeiture of earned but undistributed wages, right? So undistributed means that the employer still has control. If the employer has my cash, they still have control of my cash, right? So equity shouldn't be treated any differently. And I will say this, to the extent that Lerner does hold that Geary properly cites to Truelove, I just assert to the court that the word value to the employee is used in Geary, it's relied on in Lerner, and it is said nowhere in Truelove. The Court of Appeals did not say anything about the value to the employee.
The comment I have about wages versus equity, wages are a set component. That's a dollar figure that's going to be not susceptible to, the company's up and down. That's your compensation. But equity, that goes up and down depending on how the company's going, right?
So Justice Oing, that's precisely the issue. These days, that is somebody's compensation.
Yeah.
These days, vast amounts of people in the tech industry are paid exclusively through equity. If we accept that from New York labor law, then we're going contrary to what the legislature wants, which is for us to be a leading state in protecting employees' rights to wages. Thank you.
Okay. Thank you. Thank you all.
Oh, okay. Next time, just let us know. We'll bring you your copy. No. Good night.